Good evening, Mayor Allen. It is 6:30 and you do have quorum on camera, so you may begin when you're ready.
Thank you, Deputy Clerk. Can I have a mover and seconder to call the meeting to order? Councillor Maude Chapman, Deputy Mayor Coghlan, that the regular meeting of the Council Township of Springwater of October 6, 2021 come to order at 6:30 p.m. All those in favor? That is carried. Due to COVID, Council is taking the necessary steps to limit in-person meetings. As such, members of Council and staff are participating using Zoom. The meeting will be live streamed. You can watch the meeting live on the Township's website, www.springwater.ca. You can listen to it by telephone by calling into 647-558-0588 and using the meeting ID 839-5354-4356. This option is available during the meeting. Those unable to watch the live stream who are interested in seeing it can view it their convenience by watching the video on the Township's YouTube channel. Council, are there any disclosure of pecuniary interest this evening? Deputy Mayor Coghlan.
Thank you, Mayor Allen. 10.2.
10.2, noted, thank you. Any others? Okay. Can I have a mover and seconder to call the public meeting to order, please? Deputy Mayor Coghlan, Councillor Cabral. That this public meeting of council held under Section 34 of the Planning Act for the temporary use bylaw application TU 2021-003 by Smith Brothers Farm Incorporated be called to order at 6:32 p.m. All those in favor? That is carried. Welcome to this public meeting of Springwater Township Council, held in compliance with Section 34 and 39 of the Planning Act, to give the public an opportunity to express their views in regard to proposed amendments to the Township of Springwater zoning bylaws amended. The first part of this meeting is to present the amendment. Following, the public will be given the opportunity to make an oral submission through the Zoom application. Any person wishing to make an oral submission must have notified the Township prior to 8:30 a.m. this morning and must have been added to the commenters list. If a person or public body who files an appeal of a decision of the Township of Springwater in respect of a temporary use application does not make oral submissions at a public meeting or written submissions to the Township of Springwater before the proposed temporary use bylaws pass, the Ontario Land Tribunal may dismiss all or part of the appeal. All comments should be addressed through myself as chair. Oral submissions will be included in this meeting's minutes and form part of the public record, including the name and address of the speaker as information collected under the Municipal Freedom of Information and Protection of Privacy Act. The minutes of the meeting will be posted on the Township's website. We are dealing with TU 2021-003 by Smith Brothers Farm of 1335 Floss Road 4 West. I will now call upon the Deputy Clerk to confirm notice of this meeting and the dates on which notice was given.
Thank you, Mayor Allen. Notice of this public meeting was mailed on the 16th day of September 2021 to the owner of the subject lands and to the assessed owners of 48 properties in the Township of Springwater within 240 meters of the area to which the proposed temporary use would apply, and to all persons and public bodies as prescribed under the Planning Act and its regulations. Notice was also posted at the assessed properties to which the proposed amendment applies at locations visible from Floss Road 4 West. The notice was also placed on the Township's website.
Thank you. Has the Planning Department received any correspondence in response to the notice of public meeting?
Yes, items of correspondence have been received from the following. the Nottawasaga Valley Conservation Authority in an email dated September 20th, 2021. Chris and Paul Toy of 40 O'Neill Circle in an email dated September 29th, 2021. The County of Simcoe Planning Department in an email dated September 29th, 2021. Alicia Roper of 21 Hall Street in an email dated October 1st, 2021. Sean McGinnis of 31 Marl Creek Drive in an email dated October 2nd, 2021. Dave Havalika of Phelpston in an email dated October 3rd, 2021. Mitch Simpson of 52 O'Neill Circle in an email dated October 3rd, 2021. Sharon Harris of 8 Buckley Street in an email dated October 3rd, 2021. Trevor Carter of 1381 Floss Road 4 West in person on October 4th, 2021. Lynn and Michael Harper of 39 O'Neill Circle in an email dated October 4th, 2021. Marjorie Tedder and Michael Ulicki of 50 O'Neill Circle in an email dated October 4th, 2021. Roland Desjardins of 16 O'Neill Circle in an email dated October 4th, 2021. Laura Johnson of 1668 Floss Road 4 West in an email dated October 5th, 2021. Community petition submitted by Beverly Clark on October 5th, 2021. Sid and Joan Price of 1138 Floss Road 4 West in an email dated October 5th, 2021. Sarah, Ray, and Sheila Corbett of 43 Tona Trail and 7398 County Road 91 respectively in an email dated October 6th, 2021. And Robin Bardens in an email dated October 6th, 2021. All of these submissions were attached to the agenda for review. And there were a number of comments that were received late this afternoon that unfortunately were not added to the agenda, but they have been received.
And they will be all included in the agenda as posted, Deputy Clerk?
We can republish the agenda, sure.
Yeah, so that will be the place to capture all of the comments, will it?
Yes, yeah.
Okay, thank you. I now call upon Patrick Towns of MHBC to give a presentation outlining the purpose and effect of this proposal.
Thank you, Mayor Allen. Can everyone hear me and see the slide presentation?
We can, yes, thank you.
Great, thank you. And thank you again, Mayor Allen, members of council, staff, and the members of the public viewing tonight's meeting. As mentioned, my name is Patrick Towns. I'm a land use planner with MHBC Planning in Barrie. I'm here tonight to provide the overview of the proposed temporary use application on behalf of our clients, the owners, Smith Brothers Farms. And just excuse me if I appear to my left, I'm operating on a second screen. So the application before you this evening is for a temporary use. It's to permit a baseball training facility on the subject property at 1335 Floss Road 4 West, which is generally located just outside of the Phelpston settlement area to the east side. The proposed use is going to be conducted completely within 2 existing buildings on the subject property, where one of the buildings will be used for a gym and the other will be used for batting tunnels. The owners are seeking permission to conduct this, the use for a temporary period of time, 18 months or a year and a half. And that's so they can get their business up and running indoors prior to the winter season, which unfortunately or fortunately, depending on your view, is quickly approaching here. The owners did present and had an opportunity to delegate before council at a previous meeting where they introduced their future plans for the subject property. Those future plans do include expansions to the buildings and outdoor playing fields. The owners are preparing the required information and necessary approvals and applications for this future use, which will be submitted at a future council meeting. So the application before you tonight is solely for a temporary use to use those existing 2 buildings, and there's no permanent structures being proposed at this time. As mentioned, the property is generally located east of Phelpston and west of Highway 27 that runs between Elmvale and Midhurst. The subject property is approximately 100 acres. Of that 100 acres, the existing residential and agricultural field occupies 17 acres, so a small percentage of that. There's an existing dwelling and it's serviced by an existing well and septic system. This slide shows an aerial image of the subject property. It clearly shows the areas of cleared and agricultural lands compared to the forested area. The forested lands contain environmental features which are protected when it comes to provincial policy statements and plans, and the local planning documents at the county and the township, which we'll dive into a little further here. In both the county and township official plans, the front portion of the subject property where the existing development is located is designated rural. This is, of course, an important consideration when evaluating the permitted land uses on the subject property. The owners have been looking at other properties in the area, and it's honestly tough to find a property designated rural. Oftentimes you're dealing with agricultural lands or protected lands, but in this case, the rural designation does permit these types of uses. And as mentioned, the back portion of the property is protected and no development is contemplated now or in the future within this area. So the Township of Springwater official plan specifically permits tourist and recreational commercial uses within the rural designation, and that's what this proposed use would fall under. And just as a comparison, some other permitted uses in the rural designation include, I'll just refer to my list here, but highway and service commercial uses, light industrial uses, private clubs, agricultural equipment repair, farm supply dealerships, kennels, greenhouse production, and that's just to name a few other examples of land uses that are permitted within the rural designation of the official plan. So now looking at the provincial policies and plans, the proposed use is considered a rural land use, and the PPS promotes recreation and economic opportunities, and the growth plan permits development that is compatible with surrounding land uses. And compatibility is a key issue. Compatibility is considered under the township official plan and has been considered as a result of the current proposal currently before you, and it will be evaluated further at a future time for the full development of the property. So the township official plan specifically, it does include policies and criteria that must be met for temporary uses. These policies have been reviewed and township staff agree in their planning report with the analysis and planning letter that we provided in the application package in support of the temporary use in this case. Overall, the proposed use is temporary in nature. It only utilizes the existing buildings at present time indoors. And it's such, there's no impacts on noise or anything like that. The size of the property is appropriate for this use. The use is appropriate for private services. It doesn't require any hookups to water and sewer, and it's appropriate generally for the rural area. And at present time, no anticipated land use conflicts are anticipated. The property is currently zoned agricultural in the zoning bylaw at the front of the property. Through the proposed temporary use, site-specific regulations are proposed, and those are to limit what's permitted during that 18-month period. And again, that includes the use of only the 2 existing buildings and a maximum of 20 spaces, parking spaces, that is, sorry. So again, the approval of the temporary use is proposed to lapse at the end of that 18-month or 1.5-year period. And at such time, during that time, the applicants, the owners will be providing formal applications for the additional elements of the business that were mentioned in the original delegation before council. So just to be clear, the proposed temporary use is to permit the proposed gym and the batting tunnels within the 2 existing buildings that sit there today. So this slide, it shows an image zoomed into the front portion of the property. It shows the location of there's 3 buildings, accessory buildings. Only 2 are proposed to be used as the batting tunnel and the gym. The other one will just be used for storage as it is there today. As mentioned, the back of the property or the forested area, it is protected in terms of provincial plans and policies. And future development will even require a 30-meter buffer from that area. So that's an important consideration that was discussed through the pre-consultation with MVCA, the county, and the township. This slide it includes a zoomed in version, just showing the 2 buildings. The gym is towards the north, or sorry, the top of this image, and then the batting tunnel is on the left. And just a few site photos for context. Here's a view from the front of the property. The accessory buildings are clustered on the left side. The existing dwelling is located on the right. This image shows the proposed gym, the existing storage building, and then the building to be used for the batting tunnels. Similar image here of the existing buildings. And that's just a shot of the existing building to be used for the gym. That does conclude my presentation, but I understand that there has been a number of comments submitted and in favor and against the proposed use at this time. So I would like to take some time to hopefully address those concerns. So regarding the proposed buildings and the proposed lights and the potential impacts on the surrounding properties, there's currently no additional buildings proposed associated with the indoor baseball training facility, and there are no lights proposed. In fact, the future plans for the baseball diamonds themselves at current time do not include any plans for lighting. And the majority of concerns that were provided related to these specific items. Specifically regarding traffic, Floss Road 4 West, it's identified as an arterial road in the official plan, and it's designed in a manner to accommodate this type of traffic. Of note, current permitted uses within the agricultural zone, so these are permitted as of right now for the property. They may include things as like a veterinary clinic, a home industry, a market garden, or a farm produce sales outlet. So we feel in terms of intensity or potential for traffic that this proposed use is similar to those in nature and won't create any traffic hazards. And another important comment that was provided is regarding the loss of farmland. So from a PPS perspective, that's the provincial policy statement. From the growth plan, the county and the township land use perspectives, the property is considered rural and designated rural. It's not designated agricultural. So therefore, it's subject to different permitted uses than what could occur on agricultural designated land. So the portion of the property used for agricultural currently is small in comparison to the overall size of 100 acres. And then again, the back portion is protected in addition to 30 meters of the boundary of the existing woodland. So in terms of farm property, it's fairly limited in size, and again, designated rural in the associated land use planning documents. So, and I would like to note just the county and NVCA provided letters of support for the proposed use. And again, I just want to attempt to address some of the comments that have been received and just confirm it's only for a temporary use within those existing buildings for a period of time. And what that does is also gives an opportunity for the owners to demonstrate that they can work in unison with the existing neighbors and provide a compatible use for this area. So that concludes my presentation, and I thank you very kindly for your time.
Thank you, Mr. Towns. I'll now call upon the moderator to provide the number of people who have registered to ask questions or make comments regarding this application.
Thank you, Mayor Allen. There are 3 commenters registered to make an oral submission in regard to this application. Rick Mueller of 1328 Floss Road 4 West is the first commenter. Rick, you may now address the mayor and council with your questions and comments. So I'm just going to unmute you.
Mayor Allen, can you hear me now?
Yes, we can.
Thank you very much. The reason I wanted to get on and talk to you was there was some confusion. I've been getting some information from some of the neighbors and that. I'd like to thank Mr. Towns for his presentation. He clarified a lot of the definitions that I was having problems with. One was a temporary length of time, and he's outlined that to be 18 months. Is that correct? Yeah.
Yes, I believe that is
Um,
correct.
Yeah, the confusion, I think, was between the agricultural and the rural designation of the property. I had been led to, it was agricultural versus rural, and I appreciate Mr. Towns explaining the difference between the two, and that puts a new light on everything here. And the other point too was I was concerned that the bush area, which is a major part of the property, might have been impacted on it. But once again, I've been reassured by Mr. Towns that in his research that is basically designated as bush and cannot be turned into residential area or anything in the future. So I'm very pleased with the presentation, and I appreciate the chance to address you. Thank you very much.
Thank you, Mr. Mueller. Next moderator.
So Trevor Carter of 1381 Floss Road 4 West is the second commenter. Trevor, you may now address the mayor and council with your questions and comments.
I just want to be sure you can hear me, council.
Yes, we
Yes.
can, Mr. Carter.
Okay. Great. As an adjacent property owner, directly adjacent, I have really serious concerns about the noise, stray baseballs. I've seen the diagram of what's proposed. I saw that at the September 15th presentation by the Smith Brothers company. And what I saw puts this baseball diamond literally within a stone's throw or baseball's throw of my property line. I don't know how my property value can possibly stay where it is with something directly adjacent. I could step over the bushes on the side of my property and stand on a baseball diamond. That's how close I will be. But I'll worry about that. I know right now we're talking about temporary usage of existing buildings. So when the future proposals, and I see what those are for what's planned in the field next door, come out, then I'll worry about dealing with those at that time. But I have a concern actually about the archaeological nature of what could be on that property. There's a lot of First Nation sites in the area, and with all the current focus on the truth and reconciliation issues for First Nations people, I'm wondering if an archaeological assessment is going to be done on that property before any kind of grading of any kind happens for those baseball diamonds. And that's my first concern. I'll worry about the other concerns for my property at the next stage of this when the diamond plan is proposed.
Thank you,
Thank
Mr.
you.
Carter. Mr. Towns, can you comment on the point made by Mr. Carter?
Yes, thank you, Your Worship, and thank you for the comment, Mr. Carter. We did have pre-consultation meetings with Township, and it's escaping me, but we do have a list of studies that have to be completed for that formal application. And we will, I'll circle back with staff just to see if that was a requirement, and we'll obviously address that as required. But as far as the temporary use goes, it's using existing buildings, so there's no site alteration or anything to that effect. So generally in these cases, an archaeological study is not required. But again, there are various studies that are being worked on and prepared for the formal applications to come back to the township. So I'll revisit that with Planner Belcourt and township staff just to confirm if that was a requirement, because I cannot remember at the top of my head. So
Thank you.
Yeah, okay, thank you.
Thank you, Mr. Carter. And there was a third moderator, Hawk.
Yes, so I have Susan Yao of Phelpston is the third commenter. Susan, you may now address the mayor and council with your questions or comments.
Hello, can everybody hear me?
Yes.
We basically have the same concerns as Trevor Carter. We're worried about the traffic. We're worried about our property value. We're worried about the lights and the noise, because I feel that if this temporary application goes through, it's a given for the permanent one. I've looked at the Smith Brothers building in New Lowell. It's massive. It's not that attractive, and it will be right in front of our house. And so I could really see the fact that our property value would decrease exponentially. We were under the impression that this was a meeting to assess if the temporary permit would go through, and they've already had training camps over there. And I'm not quite sure how that happens when it hasn't even been approved yet. They've had people, numerous people over there numerous times using the property. And with, we don't know if there's adequate washroom facilities or COVID distancing going on or anything like that, but that has gone on already. And we're just wondering if that's the case, you know, how are they going to adhere to rules and restrictions when they already seem to not be abiding by a temporary permit yet that they haven't even got. That's pretty much it. I think I'm more concerned about the property values, the traffic, the noise, the lights, and everything that will come if this goes through on a temporary, like the temporary one goes through and the permanent one will follow in its place, which I think everybody would know that that was the route it will go. Thank you.
Okay, thank you, Mr. Towns. Any comments with respect to Ms. Yao's comments?
Yes, thank you, Mayor Allen, and thank you, Ms. Yao. Just in response to the buildings, the owners, there's no final plans prepared for the buildings, but the owners are aware of the rural character and nature of the property. So that will be of the mindset of them when they do get the eventual plans designed. And again, they'll be presented to the township at a further meeting. And just regarding the use of the property, I spoke with the owner. They had people coming to the property just to meet, but they have rented the Phelpston Diamond to have some of their training. So that's why there has been some activity. They're aware that they're not able to do any uses on the property. And they're also aware that even if permissions are granted today, there's a 20-day appeal period in place, and they still have to get some work done on the buildings themselves. So yes, they have rented the Phelpston Diamond in the meantime to do some of their training exercises, which they'll do there. But other than that, they're aware of the zoning permissions on the property.
Pardon me, but there was training going on. It wasn't a meeting. There was kids doing training at the training camp. We live right across the road. We could see what was happening. So I would wonder if they are going to put a building up, would they put a berm up so we don't have to look at it? Like, or you know, would that even be part of their future consideration, as well as the aesthetics of the look at our door? Do we have to look at an industrial type building? Because the building in New Lowell is massive.
Okay, thank you for those comments. We're not at that stage yet, but certainly the comment is valid, and you did go to see the existing structure, so you brought that to planning staff's attention. So appreciate that, Ms. Yao. All right, moving on to council. Do any members of council have questions or comments regarding this application? Councillor Ritchie.
Thank you, Mayor Allen. Through to Patrick. Thank you for the presentation, Patrick. It's comforting to know that you've mentioned that they're using the existing baseball facility there, Diamond, just up the road. I can comment on that. We've put a nice pavilion in there. We've upgraded the bleachers. Why can't they run that whole facility that they're wanting out of that baseball diamond that's there? Because it's hardly ever used, and it's already a baseball diamond.
Unlit, but baseball diamond. You're right, Councillor Ritchie. Mr. Towns.
Thank you, Councillor Ritchie, through your worship, Mayor Allen. Comment noted. The Smith brothers were looking for a property, a rural type property that would permit this type of use, just to have the private baseball facility that they could use. Their facility in New Lowell was in an industrial area, so it was only an industrial building at that time. So all I can comment at present time is just they're looking for an area to potentially a little larger land area for a private diamond rather than renting a township diamond all the time. So it's more of just a business question, if anything, and we can address that moving forward.
Follow on, Councillor Ritchie.
Thank you, Mayor Allen, and thank you for the response. Yes, it's a 100-acre parcel, but it's not private. It's backing onto people. And I would be amiss as a councillor for this area for that ward, not to speak to the concerns that I've heard from people concerned about this. So I'm going to support my residents by not supporting this application. And I want a recorded vote on this as well, too. Thank you.
Okay, other cards were up. Councillor Cabral, did you have one? Go ahead.
Thank you, Mayor Allen. Just a couple of questions actually from my end. I noticed on your slide presentation, I don't think you need to go back to it. You indicated there's a 30-meter buffer between the environmental lands and the diamond. I noticed on the side where O'Neill Circle is, that's the subdivision immediately to the east of the property. That particular boundary line is much smaller, and I'm wondering, is that a smaller buffer, or is that just indicating the property line? Because it seems to be a little bit of area there.
Mr. Towns?
Yes, thank you, Mayor Allen, through you to Councillor Cabral. It's just the 30-meter buffer is measured specifically from the forested area and the area designated environmental protection. So that area to the west, I think you're referring to, is actually
Sorry, yes, on the west.
the back lots of those existing on O'Neill Court or Circle, sorry. So there's no environmental feature on that west side, just to the rear and to the east side of the property.
Okay, and I guess my question then would be, there's a 30-meter buffer that I guess is in place due to the NVCA, if that's where that 30-meter came from. What kind of a buffer, and if you put in a 30-meter buffer on the west side where those backyards are, would you still be able to move forward with the proposal down the road? And I guess on top of that, even though we're talking about private baseball diamonds, I know from the previous meeting that they were land constricted as far as being able to have a full facility there because they were in an industrial area. Down the road, this is a temporary use, but we know where it's headed. What can residents expect in the way of not just training, but what about competitions? What about, I don't know the word, I'm at a loss for it now. You know, all the teams come around, you're going to have a weekend
Tournaments.
full of baseball tournament. That's
Tournament.
it. Thank you ever so much.
No,
I have to look down the pipe here, much like Councillor Ritchie, and ask about those questions down the road because as some residents pointed out, a temporary use for 18 months is just in place while you look at changing things up to bring it into permanency.
Mr. Towns?
Yes, through you, Mayor Allen. Yes, it's a good point. So I think the benefit of having this meeting is, yes, this permit or this approval is just for the existing buildings, but it gives us a sense of what those comments will be and what we can attempt to address when those applications come forward. And what I've heard is in terms of land use compatibility and views from adjacent neighbors and potential foul balls and where are these balls going to be landing, whether they're home runs or foul balls. So I think this is all information we can take back. And again, we're just for the temporary use for the existing buildings currently, but we can take this information back to ensure the site is designed in a manner to take in to account these concerns and hopefully address them at that later stage.
Other questions? Deputy Mayor Coughlin?
Thank you, Mayor Allen. As Councillor Ritchie had stated, that the residents of Phelpston have been reaching out quite heavily, we'll say, over the last little bit here. And while there were members of the community who are concerned, and thank you, Mr. Towns, for alleviating the lights at the facility were, I would say, probably the #1 concern. So understanding that would not be coming forward. And I do apologize as this is, I would say, the temporary use is a gateway to the actual application. So I apologize if I pull some aspects of the next application into tonight. As far as tournaments and training go, there are also comments within the community. Phelpston is a baseball community, always has been. I don't think it's conflict. I myself am a Phelpston Cougar, and I think that baseball does bring that community together. There is lots of support for this facility, but there's, I don't want to say concern, but comments in that it is rural by nature, and understanding that Smith Brothers have now adopted the name Smith Brother Farms, I am hopeful that the aesthetics of the facility will be that of their existing surrounding locations, so that it does appear to be consistent with Phelpston. I would also like to point out that there are many members of Springwater right now who do attend this facility. I reached out to the Council of Clearview to ask if there was any bylaw infractions, if there was any neighborly disputes with them, and I have not been able to find any. So I am hopeful, and I will continue to support the application, as I do believe that bringing a facility like this to Phelpston is a far more community oriented than the existing R-rated establishment that used to be in Phelpston. So I think that this is a good move for Phelpston. I think that this can be a very beneficial thing. I know that there's members of the community who look forward to sitting in the stands or on those bleachers, as Councillor Ritchie had pointed out, to cheer on the local kids and facilities. So I thank Smith Brothers for bringing this forward through a temporary use. I will be voting in favor of it this evening, and I look forward to moving forward with them to ensure that the applications coming forth is consistent with the community that we have today.
Thank you, Councillor Moore.
Thank you, Mayor Allen. Just 2 points. You look around the township, there are many parks and baseball diamonds that are saddled up beside housing developments. So that happens everywhere. And secondly, what measures can we put in place over the next 18 months to ensure that bylaws are not being broken, or that there is some oversight to ensure that the Smith Brothers are doing exactly what the temporary use would allow them to do? And sort of what those ramifications would be if they stepped outside.
Okay, I'll go to Director Spagnell for a response to that, please.
Thank you, Mayor Allen. So with any bylaw enforcement consideration, really it comes down to the operator to stay within the confines of the bylaw. Now, the one aspect of a temporary use bylaw is that if there are any issues that are a result of non-compliance, those complaints can be submitted to the municipality for further investigation. So as far as any proactive measures, really it's a matter of identifying what the use is, and as Mr. Towns has indicated, his clients know the parameters of the zoning bylaw, so that's the educational piece. But the second part of it is that if there are any issues, bylaw enforcement would investigate to see if there was a bylaw infraction, and that matter could come before council again with respect to the consideration of the temporary nature of this use for further discussion and further review. So to Mr. Towns' point, the fact that we've got a temporary use bylaw, it's almost like a trial case in essence, and it's a trial run for the use to determine whether or not there are any pinch points or anything that is of issue that can possibly be rectified through any future applications or through site plan approval. So it's an ongoing review, and it's a matter of the operator just working within the confines of the approvals that are provided by council, if that's where council wants to go.
Thank you.
Okay, I have a question. One of the submissions was from Simcoe County, saying that talking about the natural heritage features and saying that there would have to be a natural heritage evaluation based on the letter received in the appendix from the county. Mr. Towns, what are your thoughts with respect to the points they raise?
Well, that's correct, Mayor Allen, and it is one of the requirements of the complete application. What we did is pre-consult with NVCA, the county, on the applications themselves for the end use, and they provided comments, and then the comments you're seeing are based on the scoped application for the temporary use, and on the basis that they're using the existing buildings currently. It's not the scoped EIS isn't required at present time, but it's mentioned earlier, the 30-meter buffer is actually a requirement of the growth plan and the policies within that plan. And so any future development will be analyzed through that the full EIS once the full application comes in. But as far as the temporary nature, they're using existing buildings. So both the NVCA and the county had no concerns from a natural heritage perspective for this application as presented.
Okay, Ms. Yao has asked to ask a follow-up question, but I'll complete council first and then go back to her. Deputy Mayor Coughlin.
Thank you, Marilyn. With Director Spagnell or with Planner Belcourt, would it be possible for the residents watching this evening to run through the process that would entail after? I think that there is some concern that by approving this evening a temporary use, that the additional amenities to the facility would simply be just kind of approved as they go along. But just to affirm public notice and public consultation as well moving forward.
Okay, Planner Belcourt, do you want to take that one?
Thank you, Mayor Allen. Through you to Deputy Mayor Coughlin and the rest of council. That is correct. There will be a process to come should they choose to proceed with the future proposal or complete proposal of their facility. They would require at a township level at minimum zoning bylaw amendment as well as site plan application. The zoning bylaw amendment process is a public process, very similar to this process we are completing tonight. So another public meeting would be required. Additional circulation will be required. So everybody notified for this application would get notice again. And we would be going through the same process. Following that, site plan application would be required, which goes through the engineering details and all of those studies that Patrick had alluded to earlier this evening. For instance, if lighting is proposed for the baseball diamonds, lighting plan and photometric assessment would be required as part of that. Those documents such as the environmental impact, that would be required as well and likely through the zoning bylaw process. So we have pre-consulted with them on this process and outlined a number of those studies that will be required, which they will be working towards before complete submission.
This might have been touched on before, but I asked the question, can there be conditions put on a temporary use bylaw? So could we, for instance, limit hours of operation, reiterate the fact there can be no lights? Can there be conditions placed on a temporary use?
Mayor Allen, maybe I can take the first crack at that, and if Director Spagnell or Planner Belcourt want to chime in afterwards. But the zoning, it lays out the permissions, how the buildings can be used, and there is the site plan approval component of this as well. And that's where we can look at any additional measures that have to be put in place that say no lights, for example. So it's kind of a two-pronged approval in the bylaw being approved that recognizes the use can occur within the two buildings. And then there's also that site plan approval stage that gets into more details about the site operation itself.
Yes, but the timing of the site plan vis-a-vis the activation of the temporary use bylaw, we want to make sure that the proper caveats and controls are put in place from the start of the temporary use bylaw. So Planner Belcourt, how could that be incorporated?
Thank you, Mayor Allen. To add to what Patrick said, so in the temporary use bylaw, it does state specifically that this is limited to the two buildings and the size of those buildings that is existing. There's also a limit on the number of parking spaces that will be available to limit traffic to the site. There's also a definition of what an indoor baseball facility is as part of that rezoning. Further to that, with a temporary use bylaw, you do have to enter into a temporary use agreement to ensure that the site is rehabilitated at the end of the expiry of that term to the satisfaction of the township. So there will be an agreement as well in conjunction with this bylaw.
Okay, any other questions of council? Councillor Hannah?
Thank you, Mayor. Just for clarification, if this is approved for temporary tonight, does it still go to a public meeting so the residents in the area have an opportunity to have input?
I believe this is it, but Planner Belcourt?
Thank you. Tonight is the public meeting for the temporary use application. However, should the applicants submit an application for the full proposal of their facility, which includes the outdoor component, there will be a public meeting also associated with that. So if they want to make this permanent and or expand to their full proposal, another public meeting will be held.
Councillor Cabral.
Thank you, Mayor Allen. Along those same lines, and I think maybe through you to Director Spagnol, a temporary use permit, if it is not approved, do they still have the same opportunity to appeal to LPAT, or is that only for permanent?
Let's go to Planner Belcourt for that, please.
Okay.
Thank you, Mayor Allen, through you to Member Cabral. My understanding is, as this is a bylaw passed under section 34 and 39 of the Planning Act, there is the same appeal mechanism as there would be under the zoning bylaw amendment, which is section 34.
Okay. All right, I don't see any further cards, so let's go back to Councillor Ma Chapman.
Thank you, Mayor Allen. Sorry about being late. Just a question about the temporary. When the 18 months is up, and are they from there, if they're not ready to apply for a permanent, can they extend the temporary?
Planner Belcourt.
Thank you, Mayor Allen. Yes, they would have to come back to ask for an extension of the temporary use in accordance with the requirements of the Planning Act.
Okay, back to Ms. Yao, who I believe wants to make a follow-up comment. Go ahead, Ms. Yao.
Yes, the training facility in New Lowell is totally in an industrial area, does not back onto residential, unlike this one. And I'm not against a small community diamond. This is not what we're talking about. And I don't think anybody that has this in their backyard or front yard, in our case, would be totally okay with this. And it's not anything to do with trying to demean community spirit or anything. And the buildings that they're proposing for the temporary, they're very small. The building in New Lowell is massive. And I'm just wondering, with all these young kids, are they going to be wearing masks? Is anybody going to monitor them for COVID? Because if they're under 12, they're not vaccinated. So again, I have that issue as well. And then when they apply for the temporary, if it is approved tonight, how soon can they apply for a permanent? Can they do that immediately and get all the plans and works for the permanent? What's the time frame?
Okay, we'll start with Mr. Towns on the COVID precautions, and then we'll swing to Planner Belcourt for the planning aspect of the question.
Thank you, Mayor Allen, and just to Mrs. Yao, the business would operate in no different than any other business in accordance with provincial regulations regarding COVID, and that's all I can say from the land use planning perspective there.
Planner Belcourt on the coordination of the permanent application.
Thank you, Mayor Allen. So should this application be approved tonight or council make a decision, as Councillor Cabral alluded to, there is a 20-day appeal period. Following that, the decision will be final. And once the temporary use agreement has been signed and executed, they will be eligible for building permit through the building department. So that is a separate process that they have to go through. But from a planning perspective, we would not be in a position to sign off on those permits until after the appeal period has been completed and the decision is final. Following that, they are welcome, just as anybody else is, to submit an application for the permanent rezoning. That is up to the applicant and their agent on their timing.
So
Okay.
am I to understand this? So 20 days after they get approved of the temporary, they can apply for a permanent building application?
Planner Belcourt.
Sorry, no, that would be to allow for the temporary use. So if they require any building permits to accommodate the proposed temporary use, such as a change of use permit for those existing structures, as they will be changing their purpose and intended use, that can occur after the 20 days. A building permit for the permanent use would not be able to be submitted until or rather signed off on until after the zoning bylaw amendment had been approved and the complete site plan application had been completed and an agreement entered into with the township. So there's quite a bit of process before we would get to building permit stage for a permanent use.
Anything to add, Director Spagnell?
Yes, thank you, Mayor Allen. I think what I'd like to clarify is that there is a separate zoning process similar to this one here that would have to occur in order to get the permanent land use permissions in place. So that would require another public meeting. It would require another circulation, another notification, and the permanent proposal would be reviewed by council and would be open to review by the public prior to any approvals on a permanent basis. So as to Planner Belcour's comments there, there is another planning process that would have to occur prior to the allowance or issuance of any building permits.
Thank you. Mr. Carter, did you have a follow-up comment?
Yes, please, if you can hear me. I'm hitting unmute a few times here. Hopefully you can hear
Yes.
me.
Yes, we
yes,
can.
okay. I just want to respond to the comment by Councillor Moore. She said that there aren't any issues with people who have small local baseball diamonds in their backyard. I think that illustrates that there's a lack of understanding of exactly what's being proposed here. This is not a small, rarely used local baseball diamond. It's a giant facility that will be used as much as possible to maximize profit with as much training as can possibly take place. And not only that, you don't normally see a residential area where a house is knocked over and a baseball diamond put in place. We were here with a rural community that is now going to be disturbed, and my property values being directly next door will suffer. And I do think that if there were two houses, you knocked one over and put in a baseball diamond beside it that was frequently used, that the remaining home would see its property value absolutely plummet. I am directly adjacent to this proposed facility. My entire future value of my property is disappearing if this goes through, as it was shown on September the 15th at that delegation. This is not a small baseball diamond. It is a large baseball diamond, and it is going to change the entire community that I moved into before this proposal was ever made. Thank you.
Thank you. Just one final question then. So to get conditions on the temporary use added, how would that happen, Planner Belcour?
Thank you, Mayor Allen. Sorry about that. You're speaking to add conditions to the agreement?
To the temporary use bylaw, to address some of the points or possibly offset some of the concerns of the residents during the temporary use bylaw period by putting conditions on the temporary use bylaw.
So thank you, Mary Ellen, for clarifying. I believe we would have to amend the proposed bylaw to include those or add them as conditions to the agreement. Perhaps Planner Towns has something to add.
Yes, if I may, Mayor Allen, thanks, Planner Belcourt. The amendment itself could be amended, but under section 34 and 39, there's only certain things that can be included under a zoning bylaw amendment. You can't say maximum number of peoples, for example. Those are all elements that can be considered at the site plan approval stage, which is required, from my understanding, even for this temporary use. So by approving the bylaw that's presented to you tonight, it's just allowing the two buildings to be used. If there's other elements that we want to incorporate, or we can work with the township, we can do that through the site plan approval stage. So whether it be hours of operation of that sort, or absolutely no lights. There's no lights proposed, but we can include that in the site plan agreement stage. And I just think that's a more appropriate way to include that rather than amending the bylaw when there's certain things you can actually include in a zoning bylaw amendment.
Okay, Deputy Mayor Coghlan.
Thank you, Marilyn. No, Patrick, or sorry, Mr. Towns addressed those in that council will have the opportunity during site plan or the future to put no lights in there, to put the hours of operation in there so that we can attest to that. But in the temporary use approval this evening, what are the hours of operation that would be permitted?
Well, that was my point. I understood that the site plan can have the conditions, but I'm saying between now and the site plan time, to what extent can we put restrictions such as hours of operation? So Planner Belcourt or Mr. Towns?
Thank you, Mayor Allen. And just to provide clarification, there's no gap between the approvals. If you were approving the bylaw this evening, you can't operate on the property till that site plan is registered, and that's when the hours can be added. So I imagine, I'm not the operator, but it would be standard hours of operation just for the indoor use at present time. But those are the items that can be included in the site plan, and the use could not occur until that agreement is in place. So there's no lag time between this evening and that site plan agreement, if that clarifies things.
So Planner Belcourt, what is the negotiation process with respect to the site plan conditions that are included at this time as part of the temporary use bylaw or in conjunction with the temporary use bylaw?
So, thank you, Mayor Allen. So we typically refer to it as a temporary use agreement. So perhaps that clarifies things slightly. In that agreement, it's normally pretty standard and really for the rehabilitation of the site upon the expiry of the agreement to set that deadline hard. But we could also add additional condition as Planner Towns has identified, which may include things such as operational hours. I would like to note that we do have noise bylaws that they would need to be cognizant of from my understanding. And I think that it's really up to council how you wish to proceed, but we could add into the resolution tonight, should you guys choose to approve it and choose to proceed with execution of a temporary use agreement, that a condition surrounding hours of operation be included. That's my suggestion. I'm not sure if Director Spagnol has any additional insight on temporary use bylaws with some similar conditions in the past.
Director Spagnol?
Thank you, Mayor Allen. Yeah, there have been some instances where in the temporary use agreement, there's been specifications regarding particulars regarding hours of operation, things of that nature. So there may be an option to do that. But I think in addition to that, I think to Mr. Towns' comments that we do have the ability to also do that through site plan control as well. And council will need to keep in mind as well that site plan control, even though this is a temporary use, those applications do come before council as well for review. So in essence, when this comes back, there are certain things that we can incorporate through further review when we're dealing with site plan that council can take a look at when we get to that step in the process.
Well, so just for clarification, Director Spagnol, then the timing of finalization of site plan versus the passing or not of the temporary use bylaw, what's the difference in timing when you, I understood Mr. Towns to say they happen in conjunction with each other.
They can happen in conjunction with one another, Mayor Allen. However, there is a little bit of a time lag in that there needs to be authorization for council, for the mayor and the clerk to execute an agreement. So that's where there might be just a little bit of a time lag where the parameters of the site plan agreement can be discussed and can be reviewed by council. But because this proposal does not incorporate any significant site development at this stage, because it's permanent in nature, it's a rather quick process, because you're essentially dealing with parking requirements and things like that. So I don't anticipate the site plan process being too long of a process. but it is something that would have to be considered by council.
Okay, any further comments by council? All right. Thank you to all who have participated in this public meeting with respect to this proposal of the temporary use application and for showing an interest in this matter. Good discussion. Can I have a mover and seconder to adjourn the public meeting, please? Deputy Mayor Coghlan, Councillor Ma Chapman, that this public meeting of council held under Section 34 of the Planning Act for TU 2021-003, Smith Brothers Farm does now adjourn at 7:30 p.m. All those in favor? That is carried. Thank you, Mr. Towns, and thank you to the residents who wrote in or called in with questions.
Thank you.
Okay. Okay, direction following the public meeting. Can I have a mover and seconder to receive the direction following the public meeting? Councillor Cabral and Deputy Mayor Coghlan. Now, this is where we have to decide whether we take it as is written here or whether we want to add any amendment potentially with respect to conditions, or whether we just depend on the site plan follow-up for conditions. Any comments of council with respect to that? Deputy Mayor Coghlan?
Thank you, Marilyn. I'm satisfied with Planner Belcourt and Director Spagnol's advice on moving forward to site plan.
Okay, so we have a mover and seconder. Any other comment? Councillor Ritchie?
Recorded vote, please.
Okay, Councillor Hannah, did you have your card up?
Just a question, is it possible to have a public meeting with reference to this so we see how the residents in the area feel? I know we've heard some of the neighbors that are going to be impacted, but it's a thing that's going to be of value or disadvantage to a lot of people in the area, and it'd be nice to hear from them all, or some of them anyway.
Deputy Clerk Marshall.
I would defer that to Director Spagnol for his comment on it.
Director Spagnol?
Thank you, Mayor Allen. So the process that we're going through right now is the public meeting process. There was notification that was served to the public. That's why we've had some residents submitting comments and providing their comments as part of the consideration for the temporary use. So this aspect of the process does represent the public meeting.
Okay, so the mover and seconder that the report from the planner regarding TU 2021-003 Smith Brothers Farm Inc. dated October 6, 2021 be received, and that the mayor and clerk be authorized to execute the necessary temporary use agreement between the township and Smith Brothers Farm Inc., and that a temporary use bylaw be forwarded to council for final approval, and a recorded vote's been requested. Deputy Clerk?
Thank you, Mayor Allen. So Councillor Ritchie has asked for a recorded vote on the motion that you just read aloud. When I call your name, please state your vote, yes or no. Councillor Cabral.
No.
Councillor Ritchie.
No.
Councillor Chapman.
Yes.
Councillor Moore.
Yes.
Councillor Hannah.
No.
Deputy Mayor Coghlan.
Yes.
And Mayor Allen.
Yes.
So that motion carries.
Okay, thank you. We are moving on to 5.1 of the agenda, which is the Elmvale End District Food Bank status update deputation presented by David Don. Mr. Don, welcome.
Thank you, Mayor Allen. Can you hear me all right?
We can, thank you.
Good. Mayor Allen and Council, I want to thank you for this opportunity to speak to you this evening regarding the Allen District Food Bank. Firstly, I'd like to thank each of you for passing the resolution to name our new food bank building in honor of Michael Stone. As mentioned in our request to have the building named after Mike, he was one of the founders of the food bank, and after 40 years of service, he is stepping down. Although Mike has done it all for the food bank, he has, as the president of the food bank, guided us through the process of obtaining the building. And the naming of the building is a fantastic way to recognize and honor Mike's service to the Elmvale and Springwater community. In May 2020, the shovels went into the ground to start the construction of the building at 62 Yonge Street North in Elmvale. And in November 2020, we opened to the public. I would like you to know that during the 2020 year, the food bank assisted 589 families and a total of 1,057 people, including 307 children aged 17 or younger. To celebrate our first year at our new home, we are hosting an open house on Saturday, October 16th from 10 a.m. to 2 p.m. And during the open house, tours will be given with COVID safety protocols being adhered to. Our volunteers are very excited to finally be able to show off our new building and to answer any questions from the public regarding the operations of the food bank. The reason I'm here this evening, Mayor Allen, is to invite you and on the members of your council to attend at 11 o'clock on the 16th of October to officially name the building after Michael Stone as the Michael Stone Building. But there is one other reason I would like to invite you to attend our open house. As you know, the Elmvale District Food Bank entered into a lease agreement with the township where the food bank agreed to repay the capital costs that were front-ended by the township for the construction of the building. Those capital costs were $284,178.91, and this money is to be paid off over the next 10 years. I'm thrilled to report that through the generosity of our community, whether it be through service clubs like the Elmvale Lions Club and others, community groups like the local firefighters associations and junior farmers, local businesses, private donations, memorial donations, and even children collecting money in their neighborhoods. Because of all this generosity, we are able to pay out the whole amount of this capital cost this year. And we would like to make a formal check presentation to you at that open house. In closing, on behalf of the Elmvale District Food Bank Board of Directors and the volunteers, I want to thank you, Mayor Allen, and the Springwater Council for your foresight and support, and all the township staff for everything you've done to assist in making the new home of the Elmvale District Food Bank a reality. Thank you.
That is fantastic news. Thank you, Mr. Don.
That's amazing.
I wonder if the township could solicit your services to raise some funds for us, because you're obviously very good at it, so.
It wasn't me, it was the community, Mr. Mayor.
So I'll definitely be attending, and hopefully other council members will as well, but that's fantastic. We appreciate your message, and very, very well done. That's incredible. I did not think that that would happen. Can I have a mover and seconder to get this on the floor, please? Councillor Ma and Councillor Ritchie. Go ahead, Councillor Ritchie.
Thank you, Mayor Allen. I thank the gentleman there, Dave Don, for the presentation. And I remember when they came to us, I believe in Mr. Belcourt, put the presentation on before council. And I remember speaking to it that I didn't have a problem with them paying all of this money back, but I had no idea and totally surprised that they would have it paid back so soon. And it just shows you the generosity of our community, and I'll leave it at that. That is sure great news. Thanks.
Thank you. Thank you very much. All right, the motion is that the delegation from David Don of the Elmvale District Food Bank be received. All those in favor? That is carried. Thank you again, Mr. Don. We'll look forward to seeing you at the open house.
Thank you very much, Mr. Mayor.
Thank you. We are at item 5.2, which has been rescheduled to the October 20th, 2021 regular meeting of council, this delegation. So we move to question period, item 6 on the agenda, where members of the public can ask questions of council or make comments regarding an item on the agenda. Questions are submitted to the clerk's office in writing by noon of the day of the meeting. Further details are outlined on tonight's agenda with respect to that. You can write in a question or make an oral submission of a question. So I turn to the deputy clerk. Have there been any questions for tonight's meeting?
Thank you, Mayor Allen. There have been no question period submissions for tonight's meeting.
Thank you. So moving on to 7.1, adoption of minutes of council. Can I have a mover and seconder to get this on the floor, please? Deputy Mayor Coghlan and Councillor Moore. We have 4 minutes listed there. Any comments with respect to these? The motion is that the minutes of council listed herein be approved as presented. Special meeting of council September 13th. Special meeting of council closed session September 15th. Special meeting of council September 15th, 2021. Minutes of the regular meeting of council September 15th, 2021. All those in favor? That's carried. 7.3, minutes of boards and committees. Mover and seconder to get this on the floor. Councillor Cabral, Councillor Moore. Minutes 1 through 5. Any comments with respect to these? The motion reads that the minutes of boards, committees, and other organizations listed herein be received as information. Broadband, Community Broadband Advisory Committee meeting, May 11. Springwater Public Library Board meeting, June 15. Efficiency and Service Delivery Audit Ad Hoc Committee, March 8. Efficiency and Service Delivery Audit Ad Hoc Committee, May 20th. And Efficiency and Service Delivery Audit Ad Hoc Committee meeting August 30, 2021. All those in favor? That is carried. No correspondence and information items. So we move to 9.1, which is the approval of recommendations of the Efficiency and Service Delivery Audit Ad Hoc Committee. And I have a mover and seconder to get this on the floor, please. Deputy Mayor Coghlan, Councillor Maud Chapman. Are there any questions or discussions with respect to this item? The item reads that the recommendation from the Efficiency and Service Delivery Audit Ad Hoc Committee contained in item 9.2 be approved as presented. All those in favor? That is carried. 9.2, the award of service delivery review IT master plan. One second. Yeah. Can I have a mover and seconder to get this on the floor, please?
Yes, ma'am.
Deputy Clerk Marshall.
Yes, sorry, Mayor Allen, thank you. So that does not need a mover and seconder or to be voted on. That was what you just voted on in the above recommendation.
Oh, yes. Yeah. I'm sorry.
Yep.
It's worded separately in my notes here. So thank you. Okay, so we're moving on to action reports. 10.1. And can I have a mover and seconder to get this on the floor, please? Councillor Cabral, Councillor Moore. Okay, before we get into this, I'll turn to Director Radigan. Comprehensive report, but just give us the highlights, please, and what the options refer to.
Thank you, Mayor Allen. Through you to members of council. The purpose of this report is to provide details pertaining to the proposed procurement bylaw update and provide options pertaining to the specific authority limits as requested by council at the September regular meeting of council. The options provided in this report reflect industry standards and allow for an appropriate level of governance, management, and efficiencies. The current process compared to the proposed process follows a similar, if not identical, approach to ensure members of council are fully informed of all newly awarded contracts on a consistent basis. Any contracts that do not meet the budget or technical requirements of the procurement process or are not within management's award authority limits must be brought forward to council for consideration and further discussion. The report before you outlines a clear duplication of services in terms of staff time, which can be eliminated to provide for greater efficiencies within the organization. An example of this is included on today's agenda. It may not be a good example, but I just wanted to provide it something in context. The award of the IT master plan has technically been prolonged by approximately 52 days, as the request for proposal closed on August 11th, 2021. Although the recommended proponent has met all the technical and financial requirements within the request for proposal, the current bylaw doesn't provide staff with the authority to award, even though the RFP document is considered a legally binding document. Staff have proposed 3 options within the report before you, and believe these options provide for further efficiencies and will allow staff to proceed with projects and awarding of contracts in a more timely, transparent, and efficient manner. Thank you, and I'd be happy to answer any of your questions.
Okay, open it up to council. Councillor Hannah.
Thank you, Mayor. I'd like to propose a suggestion that would probably speed up and avoid a lot of dialogue, and that we add option 4 and state to the effect that the existing procurement bylaw be maintained.
Director Radigan.
Thank you. Through you, Mayor Allen. I do want to provide further clarification. The existing bylaw is technically expired. We did go through it, and it does specifically state that it has expired. So a new bylaw, whether it's the same components as the existing one, I think just in terms of how it's worded, I think we would need to clarify that.
Okay, so follow up, Councillor Hannah.
Thank you. I guess I didn't realize that our bylaw is expired. So I'm just trying to move the evening forward by suggesting that we maintain the existing bylaw or that we reinstate the existing bylaw. If somebody else wants to second that, or if the rest of the council agrees that this would be a worthwhile consideration, I would appreciate it.
Thank you. Councillor Cabral.
Thank you, Mayor Allen. On review of the report, good report, it talks a lot about accountability. It talks about transparency. It talks about being able to track fairness, procurement, all of those aspects of the current bylaw that we had in place are still there. The only aspect of the current bylaw that seemingly needs to be changed is the approval. So I have to agree with Councillor Hannah that we should have an option here that allows the, even if you're going to write a new bylaw, that allows the old approval amounts in there and incorporates monthly reporting. I'm just saying, as a councillor, from my standpoint, I think council today put that in there specifically so council could be responsible. And I think it's one thing to be able to delegate responsibility, but there's one thing you cannot delegate, and that's accountability. And even though staff do work and they see it coming and going, it's during these meetings, regular council meetings, where these things come before council, are debated at the RFP stage or request for proposals, request for interest, all that kind of stuff. And then it's nice that it comes back to us later on so that not only do we get to see it again before it goes forward, but anybody who's watching or attends the meetings also gets to see it go forward. So I must admit, I was a little bit miffed that status quo wasn't there, because the whole concept was to make it quicker and easier. But in reality, yes, maybe 52 days did pass by, but that's abnormal because it was given in August. If it had been any other month of the year, I don't suspect more than 7 or 8 days would pass by before council would have another meeting. So I have to agree with Councillor Hannah. If it wasn't broken, why are we in such a rush to try and fix it? And I want to be accountable to my residents on how our money is being spent, and they should be able to see how that happens. And the only real venue or opportunity they have is through these council meetings. I like the one that was before, and if I can speak back to the last meeting, if I recall correctly, Mayor Allen, you also indicated like what was the problem with the present procurement bylaw. So I have to agree with Councillor Hannah on this. I think the old bylaw served its purpose. I think these should come before council. We're the ones that are accountable. And I think if we just turn around and say, let someone else look after it, I don't agree with that.
I don't think they were saying let someone else look after, but Director Radigan?
Thank you, through you, Mayor Allen, to Councillor Cabral. This updated bylaw has been vetted through an industry expert who has spent about 30 years in the procurement field on the legal side. So we have spent funds in terms of updating the bylaw and ensuring that it does include best practices throughout Ontario. So there's nothing technically wrong with the old bylaw, except that it's 11 years old. And there are efficiencies to be had. And as staff, we feel compelled to raise the issue that there is a duplication of service that is taking place internally. And staff do spend quite a bit of time preparing budget as well as preparing reports for council to ensure that procurement policies are adequate and they are passed. If anything, the new process would ensure more accurate monthly reporting and would ensure that staff could proceed with projects in a more timely basis. The controls will always be there. That is an aspect of management's role that we need to ensure we manage that. And so that's why staff is coming forward and trying to improve the process. And that is what this report is requesting.
Okay, CEO Schmidt.
Thank you, Mr. Mayor. Just for the Director Radigan's comments, I guess definitely I can understand your comments, Councillor Cabral, and I can rest assure you that both Director Radigan, I'm not going to speak for Director Radigan, but Director Radigan and myself are both certified professional accountants that have a higher ethical standard that we have to uphold. And so, to be quite honest with you, if we were to not abide by that ethical code, likely both of us would not be in the positions that we're in. So I can rest assured that we are accountable. And to be honest with you, to me, there's a trust there. We do have that obligation under that certified professional accountant designation.
Okay, Councillor Ma, you had your card up.
Thank you, Mayor Allen. Just some clarifications. For example, so when we go to budget and we grant, say for the IT RFP, we grant, say, $50,000, but the department head doesn't have authority until it comes back to council. So basically, we're given approval for budget, but we don't give approval for the go-ahead until it comes back to council. I believe I'm thinking correctly. Also, my second point is, I guess on the old bylaw, why the department head had the authority of the almost 50,000, but the CEO or finance didn't have any. This didn't seem not fair, but correct. You think the CEO would have more authority than department head, but if someone can clarify the first question.
Director Radigan.
Thank you, through Mayor Allen to Councillor Ma Chapman. So that is correct. The budget is the process that provides staff with the authority to go out and tender the document based on the procurement bylaw. And in the procurement bylaw, there are specific procurement processes that staff must follow to ensure we either receive 3 quotes, go out for an RFP or RFQ, or go out for an RFP, RFT through the open procurement process. Based on those documents are binding documents. And if a proponent meets all of the requirements, whether it just be financial or whether it be the qualitative and financial requirements, we are obligated to award that tender unless there is a good reason that we cannot award. For example, if it is over budget or if it does not meet the technical requirements. Those would be very few instances, few and far between, that council could not award, and therefore the process would be canceled. An example of that actually took place this year with the fire tender, where it did come back almost double over budget. Staff obviously did not have the authority and required council's direction in terms of whether we proceeded with receiving additional budget or whether we canceled and then were provided with additional direction. So based on that, anything that is over management's authority would be coming back to council for council approval as well as council direction. This process, the proposed process, simply is suggesting a more efficient process for staff to proceed with projects and awarding tenders, and reducing the amount of time that it takes to actually award a tender. And in terms of your second question, Councillor Ma Chapman, the procurement bylaw is 11 years old. I definitely can't go back and state why it was completed in the manner that it was completed in. But what I can state is that we have spent the time, found the resources, and done our due diligence to ensure that we are meeting best practices in terms of today's practices, as well as in terms of today's dollars. And that is why staff has come forward with the dollar limits that we have and with the process that we have. Thank you.
Before getting to Councillor Hannah, I would suggest that council consider trying option 3. I mean, those are the lowest proposed options of the 3 that are set forth here. And if council feels that the rest of for the rest of this term, or a future council feels that there's not the control that it wants to have, you could always change it back to initiate the controls that the council felt were required. Councillor Hannah?
Thank you, Mayor. I respectfully disagree. But I want to make it clear first, nobody, at least especially myself, is questioning the honesty or anything about staff. People on this committee on this council ran on status of being fiscally responsible, being open and transparent. By not having these things come before council, I believe we're not being fiscally responsible to our taxpayers, and we're not being open and transparent. So, and the other thing too is, and I'm sure you know, Mayor, you can recall that when we used to have the auditor come and make the presentation before council, one of the first statements in those audit reports was a caution warning to council, stating that council was responsible for the finances of the municipality and that responsibility could not be delegated. I believe that by maintaining the procurement bylaw the way we have it, we're being fiscally responsible and we're being open and transparent. By making some of these decisions without them coming to a public council meeting, we're not being open and transparent. I believe that this is a mistake going forward. I'm not going to support any amendment other than going back and maintaining the current procurement bylaw the way it is. I just can't understand why they need to change it because it's 10 or 11 years old. If it has expired, then let's just renew it. Thank you.
Councillor Moore.
Thank you, Mayor Allen. Through you too, Director Radigan. The way I'm trying to understand this is in two pieces. So we've got the bylaw piece that was outdated, and then we've got the approval authorities for dollars, which is separate in my mind. So is there a way to update the bylaws? Because I'm sure there are other parts to the bylaw besides just the numbers piece. And then use the approval authority that we had prior. Is there a way to blend the two so that we are current with the current procurement standards?
Director Radigan.
Thank you. Through you, Mayor Allen, to Councillor Moore. A draft bylaw was presented to Council at the September 15th meeting. This report here is before you without the bylaw, as per the request of Council to come back with additional options. That is definitely a possibility to update the actual bylaw. However, keep the existing dollars. That is absolutely a possibility.
Okay, Deputy Mayor Coghlan.
Thank you, Mayor Allen. And just for my comments, I don't see this as changing a process. I think that the transparency and the accountability is the same. I think what we're debating here is a dollar value. Essentially, we are deciding what authority, which financial authority we are delegating, not that we can delegate, to our staff. Understanding that this was put in place 11 years ago, there's no way that a tender for what it costs to pave a road or what it costs to buy a vehicle or what it costs to hire a consultant is anything like what it was 11 years ago. This is simply keeping up with the times. This is us simply moving forward to ensure the practice is, in my opinion, other than option 3 with showing us that there's the new delegate or the authorities given there, this is no more or less transparent than the practices we already have in place. No council would go for something like that. That's not being asked of us. It's, to me, when I'm looking at this, and please correct me if I'm wrong, it's a dollar value. So this is how we become more efficient. We have spent a lot of time on this council establishing efficiencies, and it's not, in my opinion, a duplication. Triplication is not a word, but whatever it is, we approve it during budget. We have a procurement policy in place, and then we view it again for a third time. So to me, this is an efficiency. This is an established efficiency, and to maintain the status quo from 11 years ago is not acceptable, in my opinion. I think that we do need to move it forward, and if there's an amendable amount, option B, if that is privy to staff or sort of to council, I think that that's the direction that we need to go. This is not less transparent. We are not passing off our responsibility to be physically responsible. This is just simply coming into today's dollar values, in my opinion.
Director Radigan, any comment before I go to Councillor Cabral again?
Thank you, through you, Mayor Allen. To Deputy Mayor Coghlan, I would absolutely agree. It is not a change of process. It is not more or less. It is keeping up with the times, and it is simply a real discussion of dollar values and what council's appetite is in terms of seeing items come back to council for the second or third time.
Councillor Cabral.
Thank you, Mayor Allen. I have to disagree, and the only reason I disagree is council of the day back then, they picked 50,000, and directors at the time could do those contracts up to 50,000. The reason why the CAO and the director of finance did not have authority over 50,000 is because that authority was delegated to council. And if we turn around, and you know what, I don't mind seeing things twice, because I know from past council meetings that there have been discussions on contracts that have been awarded, that have come back to council, that have kind of illustrated some issues with the process that allowed us to fine tune it going down the road. So as much as it's easy to say, well, maybe 50,000 is a low threshold, I don't mind having 50,000 come before me on council once, twice, or 3 times. I think the transparency of it all, the fact that anybody can see it when they come to our meetings, the fact that we get to see it a second time and we see right then and there who it's being awarded to, because we're the ones that are saying, yep, go ahead and do it. I think that that's something that we would like to keep, because that's the only way we can still be both responsible and accountable to the people who put us in these seats. Even if we were to say, let's go to 100,000, or increase the limit to say $70,000. I still think that the next threshold, if it's $75,000, is the threshold for award contracts. You know, you say it's 11 years old, but we're not changing any of the verbiage. We're focused on what's going to be coming before council from here on in. And I, for one, I'm coming to these meetings, and if there's 2 or 3 awards, we just did one. It didn't take us too long to pass that, but we do know that we've had some awards that have taken a little bit of time, and there have been discussion on those awards. And that would be lost if we simply said that our threshold for council is going to be, say, $500,000, and that any award underneath that, once it's been approved, we say, here's $300,000 budget, and then $295,000 gets spent, or is it $240,000 when the award comes due? But we don't get to be involved, and residents don't really necessarily get to see that. That's why I'm struggling with this here particular way of doing things. I just had a fast look at Innisfil's per se, and theirs doesn't really define when it comes back to council or not. It just talks about their procurement policy and what the limits were. So that's the difficulty I see. And we have had many awards come back where we have had open discussion at council and then ultimately awarded it. However, based on the one that happened the last time when it came back before council with respect to the fire hall, that was an example. But if it was a lower amount and council thought that it should go back and it was something that council believed shouldn't be awarded, we've lost that opportunity moving forward from this point on. If we adopt these higher limits.
Director Radigan.
Through you, Mayor Allen, to Councillor Cabral, there were many comments made. So I will just focus in on a few of them. Council does not lose any control or does not lose the opportunity to discuss the procurements. Council will always have the opportunity. And within the report, I do outline those times that reports would come back to council for their consideration if it is over budget or if it is not within management's award authority, or if there are other technical issues with the tender. Council would be that body that provides the direction and the approval. The way it stands today is the majority of requests for proposals, not the majority, all requests for proposal documents, requests for quotation documents, and requests for tender documents, they are legally binding documents. And as a result, staff as well as council don't have that authority to back down or not award unless there is a very good reason. Otherwise, we are at the risk of litigation. And part of this process would ensure a timely amount of reporting, regardless of whether it needed a council approval or not. It would come to council on a monthly basis for council information. It would be on a report as an information report, which would allow council to still see the awards on a monthly basis. And that could be based on, all three options do provide different dollar values as well. And that could be based on council's appetite, that could be increased or decreased, and it could be more frequent. And to say that residents would not see the procurements, technically it is something that would happen in the budget process where staff do outline the items that come forward, the projects that come forward. The majority of the capital projects, those are the ones that are tendered or are put out in an open competition. And that is the process that council and staff spend time in discussing and ensuring that the requirements that are out there are put in place to ensure that a procurement process is followed. And at the end of the day, the time that we do take to spend to put the budget in place is it allows staff to go back and put together an RFQ or an RFP in a timely manner and send it out to open market and come back and be able to award it and move forward, while at the same time being able to report to council on a monthly basis of those awards. And if there are any concerns in terms of technical issues or budget issues, staff would be coming back to council.
Follow up, Mayor Allen?
Yes, go ahead.
I think what I'm hearing is that if there's a problem, staff are going to come back to council. Okay, but in situations where staff don't perceive a problem, they're just going to move ahead with it. I like checks and balances. And if it comes back before council and council perceives a problem with it, there's an opportunity to discuss it. It's kind of like doing things and then trying to review them later on. Well, it's too late for council to review something that's already been awarded and the contract's been done. Whereas the process right now is that we put it in the budget and then it comes back to us and we agree with the awarding of it moving forward. So if I take, for instance, here, option number one, we have a $400,000 budgeted item, and it's just going to be put out for an RFP, and that'll be the last council hears of it until we get a report back from staff in a written form. And then if one of us wants to discuss it, we can. The problem is that there's very little to discuss. It's already a done deal. Council didn't have an opportunity to voice any concerns with it beforehand. So these limits, to me, are just way too high.
Okay, Deputy Mayor Cog, I'll let you respond, Director Radigan.
Thank you, Mayor Allen. Through you to Councillor Cabral. I absolutely understand your concern. It is a change. We as staff are happy to reduce the values to something that is more comfortable for council. But I would like to ensure and to reiterate that the checks and balances are what the procurement document is. Those are the checks and balances. It's a legally binding document where staff and council don't have much authority unless the proponents do not provide the technical or do not meet the technical or financial requirements. And that's essentially where the duplication comes in, where council is simply providing a rubber stamp at the final stage. There are very few procurements that have been canceled to date. And I believe the one major one that we can all recall is the fire station. But normally it is very few and far between where they don't meet the obligations or the requirements within the documents.
Deputy Mayor Coughlin.
Thank you, Marilyn. I think that I would just be talking around in circles if I was to continue. I think that my understanding of the process is different. I think that regardless of the dollar figure, it comes back to council already approved. The approval process is during the budget. The procurement process is approved by council and it's a legally binding document. I would like to also add that if we were to move forward with the existing bylaw as members of council have suggested, the authority that's offered in option 3, if that is palatable. Also, $50,000 in 2010 is now $62,000. So at the very least, I think that council should consider inflation, and we should make sure that at the very least, we're moving to a number of 65 at the minimum.
Okay, any other comments from council? Are you proposing option 3 then, Deputy Mayor Coughlin? Go ahead.
Thank you. Yes, I would like to propose option 3, but I would like to have it at 65. Inflation is bringing 2010 numbers that, as Councillor Cabral says, council of the day chose $50,000 and they did it responsibly. I think that we can maintain that exact same diligence and use inflation, bring it to 65, and it's the exact same bylaw moving forward. Essentially, my apologies, understanding that the bylaw today is outdated. So yeah, I would like to put forward an amendment first.
Is there a seconder to that amendment? Councillor Ma? I had Councillor Ritchie first, then Councillor Cabral. Yeah, do you want to comment, Councillor Ritchie?
Yes, I want to, yes, and I don't know why, I felt that there should have been an option 4 where we could renew the old one. If the old one is expired, why can't we just renew it and move forward? It's worked fine all these years. And, like the old term says on the farm, it's too late after you let the horses out of the barn. And you know what? If the report comes back, say, well, we've already approved it. But we're accountable. I think that's what some of the other councils are trying to say. We're accountable. How hard was it to approve this other one here just tonight? We approved it, we moved on.
Yeah.
So I'd like to renew the old one and move forward.
Okay, so we have a motion and a seconder for option 3 as amended for a dollar amount. Councillor Moore?
Oh, thank you. I thought you were going to call the vote, so I appreciate you calling on me first. I'm going to reiterate that I think the bylaw needs to be updated. It is 11 years old. So I think Director Radican had mentioned we can update the bylaw to today's standard while keeping the dollar amounts as we had prior. So no changes to the approval authorities for dollar amounts. But we update the bylaw. I think that is what other councillors are asking for, but I would hate to let the bylaw work go by, that's all.
Director Radigan, before I go to Councillor Cabral, what are your thoughts with respect to updating the bylaw? What would be involved of updating the existing bylaw? And maybe tweaking the number a little bit, what would be involved?
Thank you, Marilyn. Through you to Councillor Moore. The bylaw has been updated. The draft was presented at the September 15th council meeting. And that was updated using Marilyn Brown from MLX LLP. So we have used a lawyer to assist in updating the bylaw. Absolutely, the thresholds can be tweaked to council's desire.
Okay, Councillor Cabral.
Thank you, Mayor Allen. If I'm hearing correctly from around the table, it may be a little bit more. I think when I look at option 3, when I'm talking about limits, I'm talking about the existing authorities remaining in place. And if we want to tweak those numbers, the 49,000 and the 50,000, those are the only 2 numbers I think need tweaking. as Deputy Mayor Coughlin alluded to, maybe $65,000. I mean, maybe even $75,000 might be after 11 years pass. If it's going to come before council at 75,000, then it would be the same as the existing authorities now, just a different number in those two boxes.
Okay, but what Deputy Mayor has moved is option 3 with an adjustment to 62.5, I believe, seconded by Councillor Ma. So Deputy Mayor Coughlin.
Thank you, Mayor Allen. As the mover, I will just simply go with Councillor Moore and Councillor Cabral's and Councillor Hanna's suggestion as to just update the existing bylaw. And I do appreciate council's appetite to put in the inflated numbers. Just move forward in that sense. I'm satisfied by that. So I guess that would be a fourth option, to just simply update the existing bylaw, but take the number 50,000 and update it to Councillor Cabral said 75. And then that way it's the same process. We're all familiar with it and we can just move forward with the existing that we have. Is that correct? If I can, through you, Mayor Allen, to Councillor Cabral, is that what I'm repeating here?
Basically, yeah, that's pretty much it. If we take the old authorities, basically take our old bylaw that was 11 years old and just increase 2 numbers in there where the existing authorities are 90,000, so that the heads will be able to award those and just give us the report. But at $75,000 threshold, it comes back to council. If
That's pretty much what
palatable.
Councillor Hanna suggested in the first place. Is that not right, Councillor Hanna?
Sorry, I'm having a little bit of trouble with the audio, but I believe what Councillor Cabral and Councillor Moore, Deputy Mayor Coughlin and Perry Ritchie are saying is similar to what I would like to see happen.
Okay. So we, Deputy Mayor Coughlin?
Thank you, Marilyn. So I would like to just put forward a motion then to just simply update the existing bylaw with the threshold being increased to $75,000. And I will look to Deputy Clerk Marshall and then also for a seconder to that amendment.
Councillor Moore. Deputy Clerk, you have that? Okay. No further discussion. Oh, Councillor Ma Chapman.
Thank you, Marilyn. I'm just clarifying what everyone else is saying to get it, understand. So we're just amending this for the department head and council from the 50 to 75.
Yes. And basically updating using the format of the old expired procurement budget, but changing the limits.
Thank you.
Okay, all those in favor? Opposed? That is carried. Okay, moving on to the main motion.
Yes, the main motion as amended still needs to be voted on.
Okay, I'll let you read that, Deputy Clerk Marshall, please.
Sure. That the report from the Director of Finance regarding the procurement bylaw options dated October 6th, 2021 be received. And that the third paragraph be amended to add that council direct that the existing procurement bylaw be presented, and that Schedule B, the award authority of the procurement bylaw, defines the limits as follows. And then there's the chart and the department head. The new authority is updated to state 75,000. Would you like me to share my screen?
Yes, please.
Okay. Yep.
Can I just ask a question, Mayor Allen, please?
Yes, Councillor Moore.
What is the difference between option 2 and what we're asking for? is option 2, because it includes the director of finance and the CAO and council. So what we're voting on is 75,000 across the board.
No.
No, my understanding is that any of these three options involves incorporating, updating the procurement bylaw to the recommendations by the consultant and discussed before. The purpose of this motion was basically to establish the financial limits. So if we pick one of, and the amendment that's brought forward is updating the old bylaw and incorporating an increase in the limit, is my understanding. Is that Councillor Cabral?
Thank you, Mayor Allen. I'm looking at this and I don't think this is what we're talking about. I think what we're talking about is highlighting the 75 is fine. Director of Finance and CAO should be NA again, and council should be $75,001, I guess, or greater than 75,000.
I see.
Thank you for catching that, Councillor Cabral. And then
That basically is the same chart now that exists in the previous bylaw with the $75,000 there. So council just needs to be switched to greater than 75,000.
Greater than. Thank you.
And in the final paragraph?
Yes. So this is stating that the Director of Finance would submit a quarterly status report to council. And then we can do valued it.
Question, Mayor Allen?
Yes, go ahead.
This particular last one, section 11.5, does that exist in the current bylaw that we're referring to, or is that a new addition based on those higher limits and just offering the reporting to council?
I think it's the latter, but Director Radigan?
That is correct. Through you, Mayor Allen, to Councillor Cabral, that paragraph would no longer be required as staff would be reporting on anything greater than 75,000.
Thank you.
Councillor Moore?
Thank you, Mayor Allen. Through you to Director Radigan. Can I just double check with you that this makes sense and that we are updating the bylaw, we are updating the new bylaw with those limits, and it's different than option number 2?
Director Radigan?
Thank you, Marilyn. Through you to Councillor Moore. You are correct. We will be providing the updated bylaw. However, providing an updated approval authority based on what you see before you without the Director of Finance and without the CAO.
Okay, thank you. Sorry, it's confusing.
Okay, so all those in favor? Opposed? That is carried. Okay. All right. 10.2, development charge exemptions and additional residential units. Deputy Mayor Coughlin, this is your conflict. And Deputy Mayor Coughlin is shaking her head, so she has declared a conflict. Can I have a mover and seconder to get this on the floor? Councillor Cabral, Councillor Ma Chapman. Again to you, Director Radigan.
Thank you, Mayor Allen. Through you to members of council. The purpose of this report before you is to seek council direction in terms of further restricting or broadening the amendments to zoning bylaw 5,329, which is additional residential units. And that permits second dwelling units on lands that are zoned to permit as single detached, semi-detached, and townhouse dwelling. Bylaw 500329 currently limits ARUs to a maximum size of 40% of the main dwelling or 50% where the unit is located in the basement of the main dwelling. It's staff's recommendation that the zoning bylaw remain as is, as it limits the size of the ARUs and also further clarifies the exemptions provided through the Development Charges Act for ancillary units. Myself and Director Spagno would be happy to answer any of your questions.
Thank you. First question I have is when you're looking at these percentages, if you have a situation where there's a separate building being built that has a garage, workshop, and then a dwelling on top, or proposed residence on top, do these square footages of that total building, upper and lower, is that used for the 40 to 50% determination? And in the main residence, are the square footages of the main floor and basement used?
Mayor
Director
Allen.
Radigan? Oh, sorry, Director Spagno.
My apologies, Mayor Allen. So the answer to the question is that the 40% applies to the entire building of the separate building. So what that means is that only 40%, so the accessory building can only be 40% of the total square footage for the main building on the property. Now,
Total square footage of the main building being the main floor and the basement?
that is correct, Mayor Allen. And if there's a second level as well.
Yes.
Okay.
Go ahead.
I think if that clarifies, then I won't speak anymore because I don't want to confuse confuse the bylaw any more than we need to.
Councillor Cabral.
Oops, that actually did serve to confuse me. So I have to ask Director Spagno through you, Mayor Allen. From what you said, I just want to be clear. So I can't build an accessory dwelling in my house that's 40% of the square footage in my house, and then build a 1,000-foot garage and put a 400 square foot accessory building in my garage. The accessory building, separate from my house, the square footage for an accessory dwelling in that separate building is based on the square footage of my dwelling where I live. Is that correct? It's not based on the building that you build. I think that's what Mayor Allen wanted to know. And then when you gave him that answer, I thought, wow, I thought I had it right. And
No, I think I'm clear, but so in your example, Councillor Cabral, walk through your numbers again and your proposed building outside.
Okay, yeah, here we go. I have a house make it real simple. It's 1,000 square feet. So in my house, I can do 400 square foot, and we'll come to this later on because I'll talk about it again, 400 square feet.
Well, let me stop you right there. You say in your house, which suggests
I'm in my dwelling. I'm in my dwelling. Okay, so there's 400 square feet there if I wanted to build it in my house, but I decide not to. I want to build a double car garage with a loft above it. And the double car garage with the loft above it is 2,000 square feet. Can I build a 400 square foot dwelling, accessory dwelling in there? Or can I build an 800 square foot accessory dwelling in there?
Director Spagno?
Okay, through you, Mayor Allen, to Councillor Cabral. So the first clarification, and I believe Mayor Allen was going to touch on this. If there is a dwelling that is proposed, an additional residential unit proposed in the existing dwelling in the basement, it can be up to 50% of the total square footage in the basement. If it is anywhere else attached to the house, it can be 40% of the total square footage. So that's just one clarification. Now, the 40% for the accessory buildings where you want a garage and a residential unit, the total combined gross floor area for that building cannot exceed 40% of the total gross floor area for your dwelling.
Yep.
Okay. And so it's always, that's the gross.
Correct.
So my house is 1,000 square feet. My accessory dwelling building total can only be 400 square feet. Is that what you're saying?
That
And
would
out
be
of that
correct,
400
Councilor
square
Cabral,
feet,
yes.
that's it. Okay.
Basic algebraic equation.
Yes, and now I do have one more quick question, and my question is, what is the provincial guidelines for the accessory dwellings?
Director Spagno?
Thank you, Marilyn. The provincial guidelines really look towards providing where they can be accessory or subsidiary to the total dwelling. And there's interpretation on that where it could be anything under 50% as a general rule of thumb. The provisions that are currently in the additional residential unit bylaw were intended to try to put some form of limitation on the size of the accessory buildings, just so that those buildings did not dominate or overcrowd residential properties. And that's the purpose of the percentages and the restrictions.
You used the term attached before. I think you just meant associated with. Attachment suggests to me that there has to be an attachment between the accessory and the main building, but I don't think you meant that, right?
Mayor Allen, by attached, I was indicating that if somebody is not doing a basement apartment, say they're doing an addition, then
Yes.
that addition can be up to 40% of the gross floor area. The 50% allowance only applies to basement apartments.
So there are no different rules if the accessory building is physically attached to the house or not.
Correct.
Okay. Other questions? Councillor Hannah.
Thank you, Mayor. Just quickly through you to Director Spagno. These restrictions are just to govern whether you have to pay DCs or not, correct? You could build something bigger, but you would have to pay DCs on it once you've met all the building approvals.
Director Spagno.
Through you, Mayor Allen, to Councillor Hannah. So this is where things tend to get a little bit more confused. The land uses that we're speaking about are only strictly related to land use considerations. The percentages that are being utilized are simply to regulate the size of buildings and how large the additional residential units can be. The development charge bylaw, using the percentages and using various criteria, is a separate matter altogether. And I would leave that to Director Radigan to speak to.
Director Radigan.
Thank you, Marilyn, through you to Councillor Hannah. So the Development Charges Act, which was recently updated as a result of Bill 108, the ancillary units, the exemption for ancillary units came into effect earlier this year. And as a result of that, DCs are exempt on ancillary units based on the criteria that they are less than or equal to the existing primary dwelling. And so as a result of that, when you first go through to the beginning of the process, we start with the zoning bylaw. And as a result of the ARU bylaw, we've already put in place that an ARU must be less than 40% or 50% if it's in the basement. As a result of that, we then move on to the next step in the process, which is the development charges. And so we look at that as an ARU must be less than 40%. So therefore, it already meets those thresholds that have been outlined within the DC bylaw. The only way a DC would be applicable is if the resident were to come forward with either requesting a zoning amendment or some other type of amendment to, or a variance, a small variance. I'm not sure about the planning portions of that. And as a result of that, if it is larger than or greater than the existing primary dwelling, it would be required to pay development charges.
Okay.
Okay.
Councillor Cabral.
Thank you,
Oh,
Mayor
sorry,
Allen.
did Councillor, sorry, Councillor
no,
Ma
go ahead,
Chapman,
go
did you have a
ahead.
question? Did you have a question, Councillor Ma?
Thank you, Mayor Allen. I just need clarification what option 2 is about.
Go ahead, Director Radigan.
Thank you. Through you, Mayor Allen, to Councillor Ma Chapman. Option 2, it allows council to provide direction in terms of proceeding with a zoning bylaw amendment if council wishes to further limit or restrict the 40% and 50% of the ARU bylaw, or to further broaden it. And it's an option for council. However, staff are recommending to limit it and stay with the existing 40%.
Okay, Councillor Ritchie.
Yes, thank you, Mayor Allen. Through to the Director of Planning. I think, you know, I welcome this this legislation. I think it's overdue to the housing crisis that we're facing. And but I find Springwater to be rather unique. We are rural and urban. It's not like we're dealing with the city of Barrie. And I see this was on the news the other night there, as Barrie Council was dealing with it. But I see, like myself, out in the country where, you know, if you had a detached building built like a 40 by 60 shop and you wanted to take 40% of that, you know, that's a 900 and some square foot building. But yet if you're in, say, the village of Elmvale or Minising or Midhurst, you're more limited. So I'd like to see, make sure that we have flexibility there in these laws to accommodate that it can go forward, but still limit the size. I think that's, you know, there needs to be some leniency in our laws to accommodate that. Thank you.
Thank you. Councillor Cabral.
Thank you, Mayor Allen. I guess the point I want to make, and it kind of flows in with what Councillor Ritchie's talking about, is when we take some of the homes that are being built now that are, you know, upwards of 2,000 square feet, these folks have an opportunity for an accessory dwelling within the house or as part of another building outside of a fair size that you could actually do something with. I'm wondering if, and I'm actually looking at option 2 to provide us some opportunity to address this and look at this down the road, is we also have, in particular in the north end here in Elmvale, some basically they're wartime homes. These are small homes, probably less than 1,000 square feet, that when you take that, and they don't have basements, some of them, you take that 1,000 square feet, there's just no way that they could take advantage of this, even if they were to build an accessory building in the back. So I'm just wondering if it might be possible to set some type of threshold so that these smaller homes that do have larger lots might be able to, instead of being the 40%, might be able to be the 50%. You know, they got maybe 1,100 square feet. That would at least permit them to build a little small 500 square foot apartment in an accessory garage if they wanted to do so. The way it stands right now, they're really locked out of this completely if they wanted to have, you know, senior family members come and live with them, or maybe a daughter or a son that wanted to stay around the house, kind of like the one that we have up there on Partridge Road there, that area where they want to move to a new house and their son is coming to live in the other one, and that's going to enable them to stay on their own property a little bit longer. So I'm kind of looking at option 2, and that's kind of the reason why. So it will provide some opportunity for, not all of us picture the smaller homes, and we've got them in Elmvale. I see them all the time, and they would pretty well be locked out of this. So I'm hopeful we might be able to look at maybe trying to see if there's a way to accommodate them by increasing it to whatever the provincial government actually allows.
Okay.
And just to give them an opportunity to do it if they wanted to.
Director Spagnol, I'll start with.
Thank you, Mayor Allen. Through to Councillor Cabral. So I can definitely appreciate the comment not wanting to exclude anybody who would want to have a separate additional residential unit. The one option that is available and to anybody who's looking at doing one of these units would be either a minor variance, probably a minor variance process. And what that would allow is, it is an application, but what it allows planning staff to do is take a look at whether or not there would be any negative impacts as a result of adding, say, an additional accessory residential unit in the urban areas on properties that may be smaller and may be a little bit more difficult to navigate those types of buildings on. The way the bylaw is set up right now is it does allow for up to 700 square feet for an accessory building. Now, again, to your point about the 40% for the existing dwelling, that might limit them, but they could in effect apply for a minor variance to look for a slight increase in that to allow for the consideration of a larger building, but while still
But then
allowing planning staff to take a look at whether or not there would be any negative impacts to surrounding neighbors and whatnot as a result of that increase.
Right, I understand that, but if,
Councillor Cabral,
Sorry.
this isn't discussion. Let's follow process.
well,
Do you have
then
a
I'd like to
follow-on?
follow up, please, yes.
Okay.
I just, based on that comment, it looks like the DC exemption wouldn't apply. But the other thought that came to mind is if they went that route and they actually increased the size of their house by just applying for a normal building permit, DCs don't apply to that, or does it? And then after they'd
Spangler?
already accomplished that, I saw someone nod their head, sorry, Mayor Allen. After they did that, would they then be able to still apply for the process for an accessory dwelling?
Director Spagnol?
Through Mayor Allen to Councillor Cabral, yes, they would. There isn't any limitation on if they're going to increase the size of the house, either by adding another unit or by adding square footage to the house. There is not a restriction saying that they cannot apply for an ARU after the fact. It's simply based on the gross floor area of the house.
What is the cost for a minor variance approximately?
$1,000.
Right. Okay, who was next? Anybody? Okay, so mover and seconder, what option did the mover and seconder propose? Who were the mover and seconder, Deputy Clerk?
Mayor Allen, I don't believe you had a mover and seconder just yet.
Oh, okay. Okay, Councillor Cabral.
Yes, Mayor Allen, I would like to move that we go with option 2 would be my preference, if there's a seconder.
Is there a seconder to that? Councillor Ritchie? Any further discussion before we vote on that? All those in favor of option 2, let me just, sorry. That the report from the Director of Finance regarding development charge delegation. Am I in the right one? No, I'm not, am I? Sorry. Regarding development charge exemptions and additional residential units, ARUs, dated October 6, 2021 be received. And that council provide direction with respect to the options outlined within this report, being option 2, that staff be directed to initiate township-led zoning bylaw amendment process to amend bylaw 5000-329, whereby permitting the total gross floor area of additional residential units, secondary, ancillary to be less than or equal to the gross floor area of the existing primary dwelling. All those in favor? That is carried. Thank you.
Thank you.
Can you inform Councillor Coghlan to come back on, please? Or Deputy Mayor Coghlan. Okay, we're at 11.1 action reports. We have a slew of them, 11.2 through 11.12. Can I have a mover and second to get these on the floor? Councillor Ma Chapman, Councillor Moore. So 11.2, obviously we'll pull. Pull. Questions or desire to pull other items? Councillor Hannah,
11, 7 Sant Road.
pull that.
Yes, please.
Councillor Cabral,
11.5.
question or pull?
A question, actually. Don't need to pull it because I'll be voting for approving it.
Okay.
I just had a question about it.
Well, anything else? Okay, so we have let me just see here, 1 second. 11, 12. Yeah, I'd like to pull 11, 12. Okay, so we have a mover and seconder that action reports items 11.2 through 11.12 be received, and that the recommendations contained therein be approved as follows. 11.3, 2022 council meeting schedule. 11.4, noise bylaw exemption request, outdoor wedding, 1289 Snow Valley Road. Oh, sorry. Before I do that, Councillor Cabral had a question about 11.5. Go ahead, Councillor Cabral. Off-road
Thank you.
vehicle outreach educational program.
Yes, thank you, Mayor Allen. I found it very interesting. I thought it was a good outreach program considering we did have people complaining. So it seems to me from the report that most of the people they ran into when they were doing this, they were quite impressed. I did want to know that even though it says there's no financial implications per se because they use summer students, I wouldn't mind in future if they might be able to just tally up the hours and give us a ballpark figure, because the staff could have been, somewhere else as well. So there is a soft dollar cost attached to it. I don't think it's significant. And my second question was, does the township have ATVs for use by staff? So they're just the two items there.
Okay, I'll go to MLEO Kellington for comment on that, please.
Good evening, through you, Mayor Allen, to Councillor Cabral. Currently, I do believe that Public Works does have an old ATV that Springwater has had for over 10 years now. I'm not too sure if it's been used lately. And then I do know that the fire department, I think they have a gator, but that's for the fire services. Other than that, I'm not really, I'd have to talk to Parks and Rec to find out if they have, I know they have their gator, but I'm not too sure about that ATV, if it's up and running, or I can find out and definitely let you know.
Yeah, it'd be interesting. I appreciate it.
Thank you.
For next year.
Okay, so going through 11.2 has been pulled. 11.3, then we're considering in this motion. 11.4, a noise bylaw, considering in this motion. 11.5, off-road vehicle outreach educational program. 11.6, municipal modernization program, citywide grant funding. 11.8, Elmville wastewater treatment plant tertiary filters reconditioning, Dynasan retrofit sole source procurement. 11.9, lift hold application LH 2021-005, RE 453211 Ontario Limited, Vesper Valley Estates Phase 3. 11.10, SP 2021-006 Miller Lumber. 1111 SU 2020-001 and ZB 220-012 Springwater Development Corporation, 1256 Wilson Avenue, with the exception of 11.2, 11.7, and 11.12. All those in favor? That is carried. Okay, let's start with 11.2. Can I have a mover and seconder then for this? Councillor Cabral and Councillor Moore. So with this, I'm just reading it again. Council authorized exemption development charges permanent by development charges. So with our discussions, Director Radigan, this still applies, right?
Thank you, through you, Mayor Allen. That is correct. This provides a recommendation that council authorize staff to return the development charges that were being held as a deposit for permit application 210152 for a resident located in Hillsdale.
Okay. Any discussion or comment, Deputy Mayor Coughlin? You're declaring conflict on this?
No, I'm not declaring a conflict, Mayor Allen, but I have not been privy to the conversations, and I'm not going to vote as I'm not comfortable. So I will be refraining from voting.
I understand. Thank you. Other comments, Council? Councillor Cabral?
Thank you, Mayor Allen. Just procedurally, would Deputy Mayor Coughlin have to remove herself from the screen because her vote will be counted as no if she abstains?
Deputy Clerk, can you give us some clarification on that?
I don't believe so, but I see Clerk Ainsworth. I don't know if she has further clarification.
Yes, thank you.
I had strict instructions to ask you the questions.
Through the mayor. So if you are on the meeting on camera and abstain from voting, it is a negative vote. So to not vote on the matter and not have it counted as a negative vote, you should not be in the meeting when the vote takes place.
Then I have to fill out that form.
Okay. Clerk Ainsworth?
Not necessarily. It's not a declaration of interest, but if you're not at the meeting during the vote, you do not vote, but it wouldn't be counted as abstaining from voting.
Deputy Mayor Coughlin?
Thank you. And procedurally, as it's not a closed session, whether my camera is on or off, I can still sit at the table. It's only during a closed session that I actually need to remove myself procedurally because I just become a member of the public, correct?
Clerk Ainsworth?
Yes, that's correct.
Okay, so we have read the motion. Any further discussion then, Council, before we vote on this? All those in favor? Opposed? That is carried. Moving on to 11.7. Sant Road, mover and seconder to get this on the floor. Councillor Hannah, who seconded Deputy Mayor Coughlin. Councillor Hannah.
Thank you, Mayor. I'm sure Council's all read the report, but I did find it interesting that that small street has 100 cars on an average a day using it. But the residents have been, for last 3 or 4 years anyway, maybe longer, asking for something to be done, excuse me, because of the concerns about speeding on that road. But if you look at the report, it says the average speed per day is only 22 kilometers an hour. Part of this report is asking that the speed limit be reduced to 40 kilometers an hour. I don't have a problem with that if that's going to be the new standard in Springwater, but the things I just can't agree with is the recommendation to put a median on Bayfield Street on 2627 highway. I think we're just creating a hazard there by putting a median in the middle of the highway, so people can't make a left turn. I would suggest that maybe zoning it with signs saying no left turn might be the first step. I can't think of anything else to do there to improve the situation, but I'm just suggesting that I would have concerns supporting putting a hazard in the middle of the highway. Mayor, you travel that road the same as I do. Occasionally in the wintertime, you get to the intersection of Snow Valley and Finley Mill, and it's hard to see the island in the snow. And that's a lit intersection with overhead lights and traffic lights. Putting an island in the road with no lights, I think is just looking for a problem. So I can't support that part of this recommendation.
I would agree with that. When I saw that possibility, I questioned whether there'd be it made any sense because of the reasons that you state, and whether it'd just be a matter of time before somebody tried to hop that median if it was there. And I really doubted whether the MTO would consider that, given the center turning lane work that they will have completed for the length up and down Bayfield Street. Putting another center of the road impediment didn't seem possible or logical to me. So you're proposing an amendment then, Councillor Hanna?
Yes, sir. I would suggest that that part of the recommendation be removed, but I would also ask that staff go and see what else can be done to try to reduce the safety problems, if you like, or increase the safety concerns in that area. As you know, there's a lot of people concerned about it, but it's the same all through Springwater, I believe. So I'm not sure what the resolution can be.
Councillor Hanna is proposing to remove the second paragraph. Is there a seconder for that motion? Amendment? Councillor Moore. Comment, Councillor Cabral.
Thank you, Mayor Allen. I appreciate that. I had actually wondered about it. I mean, I don't support the medium for the same reasons stated. Certainly, I think wintertime rolls around, plows and vehicles are going to get damaged extensively there when the median doesn't exist all the way down the roadway. But I found it a little bit unusual. We have a traffic calming policy in place, and they didn't meet the threshold when the data came in. And according to the traffic calming policy, when that happens, they can't resubmit for another, I believe, 36 months. So I'm just wondering why it's back before council. And I also have to just comment with respect to the second part, the 40 kilometers per hour limit, when it says there 22 kilometers seems to be the average speed on that road. And I think it would create problems, to be quite frankly, because at 40 kilometers, people are going to appear to be going even faster than they really are more. And the last thing is with respect to the whole community. These folks on the road have concerns, and I appreciate that. But it still is a public thoroughfare, Springwater Township roadway. If anything was going to be done there in that respect, I think it would be a much broader capture of residents in the area that might want to have some input into it. So those are my comments on that.
Okay. So we have an amendment that incorporates the first paragraph and the third paragraph. I'll read that the report from the Asset Management Coordinator regarding Sant Road traffic calming dated October 6, 2021 be received, and that an amendment to the speed limits bylaw be presented for consideration to reduce the posted speed limit on Sant Road from 50 kilometers to 40 kilometers per hour. Before we vote on that, go to Amy Goldsworth, Asset Management Coordinator, who did the report. Ms. Goldsworthy, what was the rationale for reducing the speed limit from 50 to 40, given what the findings were with respect to the 20 kilometers? Oh, we have General Manager Ramdeo. Welcome.
Yes. Good evening, Mayor Allen, members of council. The rationale was because of the geometry of the roadway, the winding nature of the roadway, we put it through a Transportation Association of Canada guideline checklist. And that guides what the speed limit ought to be given the geometry. And through that, it came in at 40 kilometers an hour. Our decision to recommend 40 kilometers an hour was based upon limiting the liability of council, of the municipality, should something happen there. We know that the recommendation is 40. If we left it at 50, that we felt puts the community or the municipality at a liability position. So that's the basis of the recommendation.
All right, Councillor Moore.
Thank you, Mayor Allen. We've had certainly many streets in our ward, or Ward 4, that we've had similar discussion, and the speed limit has never been reduced to 40. So I'm just curious, when you speak to this geometry, what are you referring to? I've never heard that before.
Yes,
sorry.
Through you, Mayor Allen, to Councillor Moore. The winding nature of Sant Road, it actually curves in a significant S shape, and that heavily influenced the outcome of the test, so to speak. We can put every road through it that the request comes in, and it'll tell us what it should be or what the recommended speed could be.
Follow on, Councillor Moore.
I just want to say that I'm going to take you up on that. Thank you very much.
Councillor Cabral.
So thank you, Mayor Allen, and through you to General Manager Ramdale. I'm just wondering, when we have situations like this where there's a speed, it could be 50, it could be 60 or whatever, and there is a bit of a sweeping curve, would it not be appropriate in that situation to put up just a typical warning sign in yellow, a cautionary sign stating that the best speed to engage that particular portion of the roadway would be 40 kilometers an hour? We do see that in many, many locations. That might be an option in this case, rather than draft up a complete bylaw per se and actually put up legislative speed limit signs on Sant Road. If all we want them to do is slow down at that particular S-bend, because I can tell you there's many other roadways, as Councillor Moore has alluded to, and there are some that actually will say, hey, slow ahead, here's a recommended cautionary speed, without reducing the speed per se on the roadway itself. Because I have some difficulty supporting the reduction, just merely because it's going to start popping up and cropping up all over the place. But I could support a 40-kilometer advisory sign at that location.
I'm not sure how I would understand the logistics of that, but General Manager Ramdale, maybe you could respond, please.
Sure. Through you, Mayor Allen, to Councillor Cabral. At this particular location, given the short distance from Highway 26 to the S Road, and also from Spence to the S Bend, given that short distance, I'm not quite sure if a road user would have enough time to slow down as they approach that 40 kilometer an hour advisory sign. So I'm not sure how that would work, and that was our concern when we were looking at this. We're not quite sure.
I do drive that, as Councillor Hanna refers to sometimes, and I did recently, just knowing this was coming up, and you really can't build up your speed to 50 because it's like a racetrack actually, but without the racing. But with the curvature, it's like a racetrack, so you can't get up to 50 to get which is why the realistic measurement was 20 on average. So to post a more realistic maximum of 40 it reflects the true actual situation of the road layout. Did you have a final comment, Councillor Cabral, before we vote on this?
Yes, I did, Mayor Allen. 50 is the standard speed everywhere in the township, and that's the issue I have. Since that's the speed limit within the township, unless otherwise posted, we could put the yellow cautionary 40-kilometer-an-hour sign, I would say, pretty well anywhere along that roadway without actually having to put up a 50-kilometer-an-hour sign. I mean, that's my thoughts. I mean, the speed limit's 50. If they go through at 10 kilometers an hour, that's okay too. Nobody has to go the speed limit. The problem we have is quite often people exceed the speed limit.
But General Manager, don't we have to, as a township, post what the speed limit is? So you can't just have a cautionary 40 when the speed limit is 50 without having it posted somewhere. Is that true?
Mayor Allen, I believe you can post cautionary speeds signs. They're, as far as I'm aware, they're not enforceable. They're cautionary, right? So the speed limit would be 50, and that would be the enforceable number.
Okay, we've had discussion on this, so we have the amendment put forward and seconded. So all those in favor of the amended motion? Is your clarification? Oh, I see cards going up here. Okay. I'll start with Clerk Ainsworth.
Thank you, Mayor Allen. There does need to be a vote on an amendment to remove the second paragraph from the main motion. And the main motion, we have a mover, or my apologies, for the amendment, we have a mover as Councillor Hannah, but no second for that.
I thought we did have a seconder. Councillor Moore was the seconder. And I realize we're voting on the amendment, which removes the middle paragraph.
Yeah.
So that's the vote that I just was taken. Any further clarification required? All those in favor of the amendment? Opposed? That is carried. Now, I don't have to read the motion, the main motion, because it's just been voted on, the amended motion.
The amendment was voted on, but the main motion as amended would need to be voted on.
And do we have a mover and seconder for that?
Yes.
Okay, the main motion is that the report from the Asset Manager Coordinator regarding Sant Road traffic calming dated October 6, 2021 be received, and that an amendment to the speed limits bylaw be presented for consideration to reduce the posted speed limit on Sant Road from 50 kilometers to 40 kilometers per hour. All those in favor? Councillor Cabral, did you want to make a point?
Yeah, I did. I just wanted to make sure that council is aware that we are agreeing to reduce this posted speed limit to 50 kilometers an hour from to 40 kilometers an hour on that single stretch of road in the township.
Yes, that's what we're doing, from 50 to 40 on that road. Yep, that was carried.
I'm sorry, I didn't really get the vote, Mayor Allen. I'll ask for a recorded vote then.
Okay.
I saw yellow signs and I had my yellow sign up.
Do you want a recorded vote or another vote?
Just another vote's fine, Mayor Allen.
Okay. All those in favor of the amendment?
That's the amendment, okay?
That is carried. Opposed? Anybody opposed? No. Okay. Going on to 11.12.
Mayor Allen?
Yes.
I have to apologize. We voted on the amendment and this was the main motion as amended. So when you just said we're going to vote on the amendment, I voted yes again because it was the original amendment that Councillor Hannah had asked for. So we're still messed up. I'm not voting for a speed reduction to 40 kilometers per hour.
Okay, Deputy Mayor Coughlin.
I apologize for the confusion.
No confusion. If we could just call the vote again for the main motion as amended, which would give Councillor Cabral the opportunity to vote. I think we just had many cards up at the same time. So if we could just call the vote for the main motion as amended.
Okay, I'm calling for the 11.7 main motion as amended. All those in favor? Opposed? That is carried. Thank you. All right, 11.12, which is Sunrise Acquisitions Elmvale, ZB 217-015 and 217-002. Can I have a mover and seconder to get this on the floor, please? Councillor Ritchie and Councillor Moore. Thank you, Director Spagnell, for sending the additional rendition of the before and after. Could you just highlight for us, please, what changes have been made and the staging of when this is proposed to happen and the purchase of the main road, the train road? Please.
Thank you, Mayor Allen. I think I'd have to say thank you to Innovative Planning Solutions for turning over the schedule very quickly for us to review. Just briefly, the changes that have occurred, the stormwater management block was moved to an area to the western side of the property to allow for emergency access to be continued on through the commercial portion of the site, which is located to the east. The plan also incorporates an additional 8 parking spots. Originally, there was 12. So now there's a total of 12 visitor parking spots to be located up in the front entrance on the condo road, which is required to be transferred over to the municipality as part of the official plan amendment and as part of a draft plan condition. In addition to that, the limits of the development were confirmed by the NVCA, and the location and the developable area have now been located outside of the hazard area, and the area is identified as for environmental protection on the plan. Those are the key changes to the proposal based on the original proposal, which came forward a couple of years ago by way of an official plan amendment. We do have Vanessa Simpson in on the call as well. She is the planning consultant working on behalf of the developer. Vanessa may be able to speak to timing and the phasing of development, Mayor Allen. With your indulgence, if I could turn it over to Vanessa, that'd be great.
Thank you. Well, welcome, Ms. Simpson. Go ahead, please.
Good evening, Mayor. So the acquisition of Train Avenue was one question I believe you had. And that is part of one of the draft plan conditions. So we are working right now on updating the appraisal, which will come back to staff. And we will move forward with the purchase of Train Avenue in the very near future. As for timing for the rest of the development, we do have to satisfy all the draft plan conditions, assuming that the applications are approved tonight. We would start moving through the detailed design process of the applications immediately. The applicants and owners of the lands are very eager to start development, so they're eager to get going right away with those reports and materials for submission and town review. And from there, I believe we might have some site plan items that we have to work through with the town, but otherwise, majority of the items would be covered through the draft plan conditions and detailed design. Does that address your questions?
Yes, it does generally. The commercial portion is completely separate from this, I appreciate. Would the commercial portion be proceeded with for approval application after the build out of this portion that we're considering now?
Through you, Mayor. We are currently starting to work through the site plan application for the commercial parcel. We have done a pre-consultation for site plan with township staff. And like you said, it is completely separate. It is anticipated that the commercial site would likely be built and constructed prior to the residential subdivision, given the difference in scale, really, and amount of work that really would be required to get us to the point of being ready to start construction. So the hope is that the commercial site would come online before the residential.
And have the commercial entities been identified yet?
Your Mayor, like you mean the final users?
Yes.
The owner has engaged a number of different possible tenants. So they are looking at a couple different restaurant uses, and as well as a retail or a beauty nail salon facility or something of that nature.
And would the blocks 1 through, can't even read the numbers, but all the blocks of the residential, would they be built in stages or all at once?
That is a good question. I don't have a firm answer on that right now. Likely there would be some phasing, but that's something we would work through with staff during detailed design.
Okay, thank you. Any further questions, comments? Councillor Cabral?
Thank you, Mayor Allen. Actually, through you, my question is with respect to where it talks about the maximum height, 13 meters. I just want to know how that plays into our fire services should they get a call.
Director Spagnell?
Thank you, Mayor Allen, through you to Councillor Cabral. As in previous discussions with council, the township does have agreements for aerial trucks and things of that nature as part of the servicing component for emergency services. So in the event of an emergency where an aerial truck is required, don't want to speak for the fire chief, but we most likely have to rely on those agreements for any apparatus needed to go and fight a fire or deal with an emergency in the development.
Yeah, thank you, Marilyn. Just quickly on that, I just wanted to know what our height is before we needed that equipment. This obviously exceeds it, is what I'm hearing then, right?
Dr. Spagnell?
Thank you, Marilyn, through to Councillor Cabral. I believe it is 11 meters.
Okay, thank you.
As per the bylaw. Yeah.
Okay. Thank you. Councillor Mon Chapman?
Thank you, Mayor Allen. Just a quick question. Is there just one entrance from Yonge Street, or is there 2?
Director Spagnell?
Thank you, Mayor Allen, through to Councillor Mon Chapman. There is one entrance off of the old Train Avenue. That would be a condo road. However, through discussions with emergency services, there is an emergency access provided through the commercial plaza to this, I guess, to the west of the development, or sorry, east of the development. And that access is to be utilized only for emergency purposes. It's not meant to be utilized for any through traffic. And those are some of the details that are going to have to be confirmed through the site plan process.
Okay, thank you. All right, we have a mover and seconder. No further questions. The motion is that the report from senior planner regarding ZB 217-015 and SU 217-002 Sunrise Acquisitions Elmville Inc. dated October 6, 2021 be received. The bylaw 5000-341 to amend zoning bylaw 5000 for Sunrise Acquisitions Elmville Inc. proposal be submitted to council for approval, and that council approve the Sunrise Acquisitions Elmville Inc. draft M plan and associated draft plan conditions subject to final engineering considerations. All those in favor? That is carried. Thank you. And thank you to the Ms. Planner. Thank you. Mason? I can't remember the name. All right. We are at information reports. There are none. Verbal reports. 13.1 official plan update. Director Spagnell.
Thank you, Mayor Allen. I have a couple of updates. The one update just relates to the official plan review. WSP is in the process of drafting a new official plan and working on policies. One of the key considerations is going to be the format of the plan, and what we are working towards is a plan that is more user-friendly and one that is more accessible from a categorization standpoint, from a formatting standpoint, than what is currently in place. So we're hoping to have those draft policies and a draft plan before council for some form of review in the next couple of months. The other matter is related to the land needs assessment and the county municipal comprehensive review process. On October 5th, the county had conducted an outreach session to go over the land needs assessment that has been conducted for the county. The purpose of the assessment was to take a look at how much land is available throughout each municipality and determine whether or not there is sufficient lands needed to accommodate growth. Some of the key findings that came out of this, and I guess as a result of that process, the county has prepared profiles and the findings for each individual municipality. Some of the key findings with respect to Springwater is that Springwater is considered to be part of the northern regional market, and the county also identified a shortfall on townhomes, semis, and apartment units, which are considered to be important housing types to be able to reduce the need for more land. And in addition to that, the county forecasts that the municipality was going to grow up to 12,710 people up to 2051. Now, as part of the outreach process, the county has identified that municipal comments are going to be received up until November 12th. So staff will be diving into the numbers for a deeper review, and we'll be providing a report to council for consideration and additional comment on November 3rd. The other finding of the county's work relates to employment, in that the county's identified 55.2 hectares of land for industrial employment lands to provide 1,426 jobs by 2051. One of the key things that staff will be looking at is the growth rates that the county is using as part of this session in comparison to the numbers that were found through the growth management strategy that was done as part of the official plan review. That will require additional review and some comment from WSP as to how this all relates, and to ensure that we're working from consistent numbers. I'm available to answer any questions that council may have.
Thank you, Director Spagnell. The other sessions are on October 18 and 19 regarding natural heritage system, watershed management, climate change, and agricultural systems. Can you give us, I know there's a registration process. I'm registered for those. Can you give us some insight on what will be covered on those?
Yeah, thank you, Mayor Allen. So the natural heritage side, the county is tasked with identifying natural heritage systems as per the provincial policies. So the sessions that they're going to be going through will be introducing mapping and the criteria that was used to identify the natural heritage systems across the county. Now, that's not to be confused with specific natural heritage features, because the province is looking at natural heritage systems. So the purpose of that will be to identify any, I guess, discrepancies or errors in the mapping where there might be something like, let's just say, an industrial subdivision that is captured as part of a natural heritage feature. So that process will be more or less to identify those lands that need to be included or excluded, but have to meet the provincial policies as it relates to natural heritage systems. The same process would apply for the agricultural areas and those systems as well, where the county will be going over their mapping and trying to refine the mapping so that it reflects the provincial policies and the definitions within the provincial policy statement and the growth plan. The mapping for the county and township mapping has been vetted through the Agricultural Advisory Committee, and it has also been vetted through the Natural Heritage, Planning Committee as well. This was done quite some time ago, where we conducted a working session to go over specific areas that should be removed and left out of the county's mapping for natural heritage and the agricultural systems. Those maps have been submitted to the county, so we will be monitoring those, the drafts that are released as part of the process, just to see on how well that reflects the work that was conducted through that committee work.
So does that review and comment on those changes, whether they were captured or not, and any further changes does that review have to be done and comments before the 12th of November as well?
It's my understanding, Mayor Allen, that they're dealing with each individual item separately, just because of the breadth of the project. I can confirm that, and we can make sure that we have the comments to reflect the needed timelines that are identified by the county. But I was of the understanding that they're receiving comments separately for each process, just because of the breadth of work that goes into each consideration.
So how do we view the changes or the current status of the natural heritage system maps and the agricultural system maps?
Mayor Allen, what we would do is we would compare our designation mapping, so the mapping that was prepared and that's in effect now, with the draft mapping that's being prepared as part of the official plan review, and essentially compare the two. Now, the one key, the one key clarification here is that local mapping tends to be a little bit more specific, and whereas when there's general mapping coming in from the higher or the upper tiers, that tends to be a little bit more broad brushed. So the county has stated that as part of this process, they are not trying to reflect local mapping, but they're trying to work within the definitions provided for by the province.
So how can we check if what I'm hearing you say then is that the county's not getting to the level of detail that interested parties, residents, agricultural farmers want to ensure that there is the accuracy at that micro level?
Yeah, so because it's an upper tier process, most likely the county will not be getting into that level of detail unless there's a blatant error in the mapping. Like I said, where, for example, you might have natural heritage lands draped over an existing subdivision or an industrial subdivision. So my understanding is that, and this is coming from the county when they went through their scope of work, that they are not going to be adjusting maps to reflect specific requests, property specific requests, but that they're going to be looking at larger type considerations or greater considerations related to urban designations and established subdivisions and things like that that don't belong within, say, the natural heritage maps.
So how does it, I'm going to the Simcoe County Federation of Agriculture tomorrow night for a meeting. They're going to want to know the logistics of providing further input with respect to heritage and agriculture. What I'm hearing is that that might not be possible to do.
Well, Mayor Allen, I wouldn't say it's not possible. I would just say that the county has stated that they're not going to be looking at fine details of the mapping. I would by no means would I say for the agricultural community not to submit their comments as it relates to their interests. They should submit their comments, and it will be up to the county to navigate through that as to what's appropriate to change the mapping and maybe what may be an inappropriate reason to change their mapping.
And how do they get to view the current status of the mapping in detail? Is that
those maps, Mayor Allen, that mapping will be released as part of a draft on the county's website
before the meetings on the 18th and 19th?
They may just release them as part of the meetings for conversation pieces and then provide opportunity for comment.
Okay. And you said you'd clarify the date for comment on the respective aspects. Okay.
Yes, I can do that, and I will send an email out to council to verify.
Thank you for the clarification. Deputy Mayor Coughlin?
Thank you, Marilyn. And my questions are about the meeting that you had earlier this week through you to Director Spagnol. You said the county identified 12,000 homes, or you said people until 2051?
Director Spagnol?
Through Mayor Allen to the Deputy Mayor, that was people.
Okay.
We were sent that by Director Spagnol as an attachment to an email. So there's a one pager that has a bunch of numbers, including that 12,000 people, which seems small to me to go from here till 2051 and say 51, right?
Right.
And say it's going to grow by 12,000 people. That doesn't jive.
And I think to that point, Mayor Allen, that will be one of the clarifications that we're seeking as to what variables and what considerations went into the forecast that had the county arrive at 12,710 people.
Yeah.
And just as a next step to this, just so that council's aware, the next step to this will be that the county will be allocating population to each individual municipality, and it will be up to each individual municipality to allocate that population to the settlement areas where they feel it's appropriate through an update to their official plans. Once the municipal comprehensive review is completed, that work has not been released yet or provided in draft form.
Okay, follow on.
And the last one, when you spoke about the industrial lands being identified, was that serviced and not serviced, or did they just encompass it in one?
Director Spagnol?
Through Mayor Allen to Deputy Mayor Coughlin. It doesn't speak to service lands or non-service lands. It just considers the total land area for employment. And in addition to that, that does not include commercial. So population serving lands is only industrial or what you consider to be industrial lands typically.
Okay, other comments to Director Spagnol? All right, thank you for that update. Economic development update, Director?
Mayor Allen, I don't have anything new to report on economic development. Thank you.
Okay, thank you. A Midhurst development update, General Manager Remdale.
Yes, hello again, Mayor Allen, Deputy Mayor Coughlin, and members of council. The major changes from my last update has been in the subdivision, they've started the work on the utilities. So that is the electrical, the gas, and the communication equipment. So that is progressing. With regards to the sales office, there was a formal opening on September 28th. And as I've been informed that sales began last Saturday, October 2nd. And that's all that I've got to report on this one.
Okay, thank you. And next we moved to county COVID updates. CEO Schmidt.
Thank you, Mr. Mayor. So just quickly here, the Township's Community Control Group does continue to monitor the situation. Our township facilities are open to the public with the exception of our community halls. As you may have heard earlier today, the federal government announced that effective October 30th, travelers will need to be fully vaccinated. So specifically, the vaccination requirement will apply to all travelers 12 years of age and older who are air passengers flying on domestic, transborder, or international flights departing from airports in Canada, rail passengers on Via Rail and Rocky Mountaineer trains, marine passengers on non-essential passenger vessels, such as cruise ships on voyages of 24 hours or more. For travelers who are in the process of being vaccinated, there will be a short transition period where they'll be able to travel if they can show a valid COVID-19 test within 72 hours of travel. By November 30th, all travelers must be fully vaccinated with very limited exceptions. From a vaccination standpoint, for Simcoe Muskoka, for the eligible population, which is 12 years and older, 85.3% have received a single dose, whereas 80% have received 2 doses. Switching to Springwater, again, eligible population 12 and over, 91.5 have received a single dose, whereas 87.2 have received 2 doses. And just finally, from a case count perspective, Springwater has had 312 confirmed cases of COVID, which is an increase of 5 cases since my last update on September 15th. 308 of those have recovered, none are in the hospital, and 2 have passed. And just finally, township staff are in the final stages of preparing our vaccination policy, and we are aiming to be bringing that to council on November 3rd. That concludes my update, Mr. Mayor.
So in Springwater, have we achieved herd immunity?
Through you, Mr. Mayor, I'm not sure that I can comment on that.
Councilor Moore, what's your opinion?
I plead the fifth.
Talk to Dr. Gardner. Councilor Cabral?
I would suggest maybe, but definitely not on weekends until November.
Okay, any other questions?
Cottage.
Any other questions of CEO Schmidt? All right, moving on to county updates. Deputy Mayor Coughlin.
Thank you, Marilyn. I think the most important one residents need to know about is the solid waste management. It's a workshop that's being presented to County Council. The consideration will be for various size carts, or essentially a smaller cart, and also the properties that carts are delivered to. Again, that's October 26th.
Okay, thank you. Moving on to municipal updates, 13.6. Does anybody have municipal updates? Councillor Ma Chapman.
Thank you, Mayor Allen. First, I'd like to thank everyone who went to the 50th anniversary of Nate Mills. I did miss that. I was away, but I did show up later. And what I did see, the place looks absolutely beautiful. The walkway's really, really, really nice. And they've had lots of movement on that walkway. The vendors were great. And as per the organizers, they said all vendors did very, very well. So it was good to see a good turnout, and the weather held up. And I thank everyone who helped participate in the making of it and who participated that day. So I thank you.
Thank you.
And the organizers.
It was a great event, and I'm glad the weather did hold. It looks very attractive, and Dennis Ganon and the rest of the crew did a great job. Continue to do a great job. Councillor Cabral, did you have your card up?
Yes, I did. Thank you, Mayor Allen. Just wanted to let everyone know, and in particular those who may be watching, the BIA's Music in the Park series. The last Saturday for that is this coming Saturday, October the 9th, and it's at the Gateway Park at the main intersection in Elmvale. And it runs from 1 p.m. to 3 p.m. And this week they're featuring the music of M. Chambers, and that's sponsored by the Elmvale BIA.
Thank you. Other municipal updates? Okay, moving on to notices of motion 14.1. There's a notice of motion regarding the intersection of Carson, Seaton, and Wilson Roads. And that motion is made by Councillor Moore, is it? I don't have that down. Is that yes. Go ahead, Councillor Moore.
So I don't think that it comes as any surprise to anyone that this.
Councillor Moore, you need a seconder, and Deputy Mayor Coughlin just put up her card. So go ahead, please.
Okay. I was saying that I don't think it comes as any surprise to anyone that this motion would be coming forward. The intersection of Carson Road and Seaton Road, or Carson and Seaton and Wilson Road, has been problematic for a really long time. Probably since my entire time on council, I've been hearing about it. And then just last week alone, there was a school bus incident on Wilson Road South. And it's just another example of the numerous accidents, the numerous close calls, and numerous concerns that I hear about almost on a daily basis. So I'll go ahead and read the motion that's prepared, and then we can talk about it after. The recommendation is, whereas residents have expressed concerns in regard to operational challenges at the intersection of Carson and Seaton and Wilson Roads in the Township of Springwater, and whereas a community petition has received more than 650 signatures requesting improvements to this intersection, and whereas the County of Simcoe is currently undertaking intersection improvements at this location, and whereas the property acquisition is complete, utility relocation and other needed planning work has commenced, and whereas the construction is anticipated to commence in 2022. Be it therefore resolved that Council of the Township of Springwater requests that the County of Simcoe make efforts to expedite the construction of the planned intersection improvements and investigate interim measures to enhance the current functioning of the intersection.
Okay, questions, discussion? Councillor Ma Chapman?
Thank you, Mayor Allen. Just a question, I guess, out to for the public to know. I know they're doing the roundabout in, it looks like it's like 2023 or the end of next year. So in the interim, are they looking at a four-way stop, or I don't think lights would be in the making since the roundabout, but maybe four-way stop? Or is that being considered, consideration?
Councillor Moore?
Thank you, Mayor Allen. Through you to Councillor Ma Chapman. So that's precisely what we're asking the county to investigate. So we're asking them to look at what would be the most appropriate interim measure to take for between now and when the roundabout is complete. So they'll have their engineers hopefully take a look at it and come up with something very quickly.
Councillor Moore, have you or Deputy Mayor Coughlin had discussions with Christian Mealy about this, and what's your current interpretation of the response from county to expedite this? Deputy Mayor Coughlin?
Thank you, Mayor Allen. Councilor Moore and myself, and it was actually CAO Aiken who we've been speaking with about preparing the motion so that it would be palatable to county council as well. Christian Mealy has also been involved in conversations, so the county is working with us, and Councilor Moore and myself will continue to reach out and to be in communication with the county as we move forward.
Okay, thank you. Any other questions before we go to vote here? Okay, all those in favor of the motion? That is carried. Thank you. Any other notices of motion? Moving on to items for future consideration. Any items for future consideration? Then moving on to bylaw approval. Can I have a mover and seconder for the approval of bylaws? Councillor Cabral, Councillor Ma Chapman. That the bylaws listed herein be signed and sealed by the mayor and clerk. 5000-340 LH 2021-005 Vesper Valley Phase Phase 3 5,341 re ZB 217-015 Elmvale Developments Inc. 5,342 TU 2021-003 Smith Brothers Farm Inc. 2021-094 amend speed limit bylaw Sant Road 2021-095 appoint chief building officer. All those in favor? That is carried. Confirmatory bylaw mover and seconder. Councillor Cabral, Councillor Ritchie. That bylaw 2021-096 to confirm and adopt the proceedings of council at the regular meeting held on October 6, 2021, listed herein be signed and sealed by the mayor and clerk. All those in favor? And that is carried. Adjournment bylaw, adjournment motion, mover and seconder. Deputy Mayor Coughlin, Councillor Moore, that the regular meeting of the Township of Springwater does now adjourn at 9:47 p.m. to meet again on regular meeting October 20, 2021 at 6:30 p.m. All those in favor? That is carried. Thank you and good night.
Happy Thanksgiving.
Yes, happy Thanksgiving. That's good.